pleasure to start our technical session. The working session is with reference to the altogether different topic. Yesterday we have seen there were different working sessions which were about artificial intelligence, social media and rule of law. That was session number 1. Then we have seen there was a visit to the Honorable Supreme Court of India where the Honorable Chief Justice of India and the next judges were there who have met the head of the delegation. Now let us start our business today. We are having almost 90 minutes, 90 minutes, and you will find that we are having 4 distinguished speakers. The sequence will be as provided in the schedule program which was already shared with us. I will be going to introduce each and every speaker. On my right you will find Rajiv Amarsurya is a speaker from Sri Lanka. He is a president of Bar Association of Sri Lanka. He is a person who had seen on this platform for a number of years. I recollect almost for last around 10 years we have seen him actively participating in different activities which includes the Law Asia activity and the POLA as well as now the Rule of Law Convention also. Now he is essentially practicing in the appellate court in the field of public law. We have seen that last few years Sri Lanka is one of the classic example where the rule of law has been reintroduced after the disturbance which was noticed by all of us. Now he is having a degree from University of Colombo and is a attorney at law in the Supreme Court of Sri Lanka also. Now, so far as today's topic is concerned, Rajiv will share his insight. We are aware the topic is having a heading between principles and enforcement, rethinking soft law and hard law in human rights. Now Rajiv and all of us have agreed that around 10 to 12 minutes per speaker will be there, and then I am sure there will be few questions which our participants may ask. So therefore, instead of spending much more time for introduction, let me invite Rajiv Amarsurya, President of Sri Lankan Bar Association, to share his thoughts. Rajiv.
President Law Asia, President Bar Association of India, and fellow presidents of the law associations of the region, colleagues on the dais, ladies and gentlemen. Warm greetings to all of you from the beautiful island of Sri Lanka, which has just been named the most beautiful island in the world. It is wonderful to be here in New Delhi at this POLA conference. Thank you very much to the Bar Association of India for the warm hospitality extended to all of us. As I mentioned yesterday at the roundtable discussion, I took over as president of the 26,000 member Bar Association of Sri Lanka earlier in March this year. And the Bar Association this year proudly celebrates its Golden Jubilee. As you know, we are a long-standing member of Law Asia, and I make an open invitation to all jurisdictions represented here today to partner with us in our journey to build and develop the legal profession and its surrounding objectives. We speak today on principles and enforcement, rethinking soft law and hard law in human rights. The term human rights is not something that is alien to any of us here today. We all know what they are, who they apply to, and we know what to do when they are breached. Human rights crises today are more complex, cross-border, and multidimensional than ever before. And when we look at it carefully and in the broader sense, we can see that it has become somewhat of a tug-of-war between the hard law and the soft law. We have the hard law, which are the treaties, the conventions, and binding instruments, including our domestic legislation. On the other hand, we have soft law, which are voluntary commitments, guidelines, and principles. Hard law carries the promise of enforceability, but often lacks and enforceability, especially in the case of dualist states like Sri Lanka. Hard law has long been seen as a cornerstone of international human rights protection. Treaties are accepted to be the most common form of hard law. Treaties such as the International Covenant on Civil and Political Rights, commonly referred to as the ICCPR, the International Covenant on Economic, Social, and Cultural Rights, and the Convention on the Elimination of All Forms of Discrimination Against Women provide the promise of legal certainty, legitimacy, and enforceability. But ladies and gentlemen, when we look at our own domestic frameworks, can we say that the full potential or the full spirit of these treaties have actually been achieved? I will now take you through one example, being one of the most recognized human rights treaties in the world, the ICCPR, the International Covenant on Civil and Political Rights. Sri Lanka, the jurisdiction which I represent, ratified the ICCPR on 11th June 1980. As Sri Lanka is a dualist state, enforceability remains reliant on the implementation of an enabling legislation to give effect to these rights. The ICCPR Act was promulgated in Sri Lanka in November 2007. This is 27 years from when it was originally signed in 1980. This legislative lethargy is not a mere technicality. It strikes at the very heart of human rights protection. For nearly 3 decades, rights that should have been accessible and justiciable remained aspirational, existing only on paper and in international fora, but denied to our people in practice. One may say the delay was due to the fact that Sri Lanka already had a chapter on fundamental rights in its constitution. However, when one does enter into an international obligation, it is with the view of enhancing its own framework of law, such that the state is not bound only by its existing domestic laws. Even when finally enacted, the act itself was narrow in scope rather than giving full domestic effect to the covenant. This reflects how delay is compounded by dilution, leaving gaps in protection and undermining the enforceability of what should be hard law. When law lags behind commitment, rights are left in limbo, and the credibility of our legal system is weakened, especially from an international perspective. Ladies and gentlemen, in October 1997, Sri Lanka made another commitment to the international framework of human rights when it ratified the optional protocol to the ICCPR of 1966. When a state ratifies the optional protocol to the ICCPR, it opens itself up to the International Individual Complaints Procedure before the UN Human Rights Committee, as all of you know. This means that once all domestic remedies have been exhausted, any citizen under the state's jurisdiction who believes their rights under the ICCPR have been violated can submit a direct complaint to the UN Human Rights Committee, and the committee will make a decision on the matter. However, the manner in which the Sri Lankan courts regarded this channel can be observed in the case of Nallaratnam Sinharasa. In this case, a Tamil national was convicted under Sri Lanka's Prevention of Terrorism Act and sentenced to a lengthy prison term after a confession that was allegedly involuntary. After exhausting domestic appeals, including before the Supreme Court, this gentleman lodged a communication under the optional protocol to the ICCPR, alleging violation of his fair trial rights, that is Article 14, prohibition on torture and ill treatment, that is Article 7, and the right to an effective remedy, Article 2, subsection 3. On the 21st of July 2004, the Human Rights Committee decided in favor of Mr. Singharasa. The committee found that Sri Lanka's handling of the confession as taking a thumbprint on a statement without proper interpretation, legal representation, safeguards violated the legal representation or safeguards violated Article 7 and 14 of the ICCPR. Critically, the committee held that Sri Lanka is under an obligation to provide an effective and appropriate remedy, including release or retrial and compensation. In September 2006, the Supreme Court of Sri Lanka rejected remedial recommendations invoking the country's dualist constitutional framework. And one cannot complain about the Supreme Court judgment, but that was how the law operates. The court held that international obligations, including both the ICCPR and the optional protocol, required domestic legislative action to become enforceable. Since Sri Lanka had not enacted implementing legislation by that time, the committee's views were not justiciable in the Sri Lankan context. The court emphasized that judicial power resides exclusively within domestic courts as per Article 105 of our Constitution. Thus, bodies like the UN Human Rights Committee cannot override these courts. In effect, the judgment stated that without legislative incorporation, there is no right, and therefore no remedy, even when the UNHRC had found a violation. This is a good example about the issues in implementation and enforcement of hard laws of the international human rights framework. That being said, there have been instances where international principles that do not form part of the Sri Lankan domestic laws have been utilized and applied by the courts of Sri Lanka. As an example, the concept of intergenerational equity was recognized in the famous Bulankulama phosphate mining case. Justice Amarasinghe stated, and I quote, "International standard-setting instruments have clearly recognized the principle of intergenerational equity. It has been stated that humankind bears a solemn responsibility to protect and improve the environment for present and future generations." That is Principle 1 of the Stockholm Declaration. The natural resources of the earth, including the air, water, land flora, and fauna, must be safeguarded for the benefit of the present and future generations. And that is Principle 2 of the Stockholm Declaration. The non-renewable resources of the earth must be employed in such a way as to guard against their future exhaustion and to ensure that benefits from such employment are shared by all humankind. That is Principle 5 of the Stockholm Declaration. The right to development must be fulfilled so as to equitably meet developmental and environmental needs of present and future generations, and that is Principle 3 of the Rio de Janeiro Declaration. The intergenerational principle, in my view, I'm quoting the judgment, should be regarded as axiomatic in the decision-making process in relation to matters concerning the natural resources and the environment of Sri Lanka in general, and particularly in the case before us. It is not something new to us, although memories may need to be jogged. Unquote. Ladies and gentlemen, soft law, in contrast, in the international sphere, are those that do not have binding force but set standards, influence state practice, and can evolve into customary law. Soft law, by contrast, has proven more agile. Instruments such as the UN Guiding Principles on Business and Human Rights or the Sustainable Development Goals can emerge and adapt rapidly to the new challenges. They broaden participation beyond states, drawing in corporates, civil society, and NGOs, and they help to shape new norms of conduct. Yet soft law also comes with risks. Without binding enforcement, it can amount to little more than rhetoric. Voluntary compliance leaves accountability to goodwill, and in some cases, the very existence of soft law commitments allows states or corporations to deflect pressure from more concrete action. What we are now witnessing is a rise of hybrid frameworks. regional models such as the European Union's due diligence laws, which are born from soft law standards but giving binding force. States commit to national action plans and voluntary pledges at Human Rights Council. Corporations are increasingly expected and sometimes compelled to adopt human rights responsibilities that transcend the failures of states. This blending of instruments suggests that the future will not be a binary choice between hard and soft law, but rather an evolving balance between the two. The central questions before us, ladies and gentlemen, are these. Can soft law evolve into customary international law? Does it complement and strengthen hard law, or does it dilute obligations by offering convenient escape routes? Should legal institutions prioritize the enforceability of binding treaties or the inclusivity and speed of voluntary commitments? In my view, the way forward lies in striking a balance. Hard law must remain the minimum guarantee of human rights protection. Soft law should continue to serve as a laboratory for innovation and rapid response. But neither can succeed alone. To bridge the gap, we must strengthen monitoring and reporting systems for soft law, ensure domestic implementation of treaty commitments, and encourage courts, national and international, to recognize the persuasive authority of soft law principles. Ultimately, whether through hard or soft law, progress depends on political will and institutional courage. The real measure of success is not the number of treaties signed or guidelines published, but whether ordinary people experience the dignity, justice, and protection that these frameworks promise. The choice before us is clear. We can allow human rights to remain caught in a tug-of-war between unenforced treaties and empty promises, or we can work to weave hard and soft law together into a coherent fabric of accountability. The challenge of our time, ladies and gentlemen, is to ensure that every commitment, binding or voluntary, translates into lived reality for those whose rights are most at risk. Thank you very much.
Thank you. This is our Sri Lankan friend who has contributed a lot and brought a clarity so far as the topic is concerned. Rajiv has contributed by sharing the experience of Sri Lanka. He shared with us about ICCPR. He also concluded ultimately by introducing the concept of balance between the hard and soft law. And most important is political will, which he referred, and the courage which institution should show. I am sure there will be several questions which must be cropping up in your mind. Please note down those questions, and there will be a question and answer session. Now the next speaker is Vice President of Taiwan Bar Association, Mr. Jason Wu. May I request whether the presentation is ready? Yes, the presentation is ready. He is going to share with us his presentation. He is a lawyer who is practicing in the intellectual property, government procurement, corporate and commercial law, as well as the cross-border transaction and the trust and estate planning. I am really impressed, Jason, the different fields which he has specialized. Apart from that, he is fluent in Mandarin, then Taiwanese and English, and we have seen him for last at least 5 years on different platform. He is one of the well-studied and a good speaker. Now the floor is yours, Jason Wu from Taiwan Bar Association, Vice President.
Thank you. Respectable President Sean Devine, and Moderator Dr. Uday, distinguished fellow speakers, collegial bar leaders, dear friends, ladies and gentlemen, good morning. The topic of this session, between principles and enforcement, rethinking soft law and hard law in human rights, encompasses 3 noun concepts: human rights, soft law, and hard law, and 1 verb: rethink. To protect human rights, was never a piece of cake. Many people sweat, bleed, and even die for it. Initially, the principles for human rights protection were upheld gradually. Then these principles were enforced through legislation, court decisions, and international treaties. Many lawyers are devoted to these processes. We call it civilization. However, in a civilized and a democratic world that we are proud of, human rights crises are becoming increasingly complex. We say hard law, which means treaties, legislation, judicial decisions, and so on. The hard law delivers enforceability and accountability. But the lawmaking and the treaty processes often lag behind. And the court decisions are notoriously time-consuming. As to soft law, it encompasses guiding principles, policy statements, and the multi-stakeholder consensus documents, which move more quickly and allow pilots. However, without institutionalization and follow-up, soft law can become a beautiful but toothless promise. We can have a simple image. In the structure for human rights protection, hard law is like a concrete walls with the binding, clear barriers that are hard to break in, but often slow to be built. On the contrary, soft law is like a scaffolding that is quick to put up and flexible, but can be blown down by the wind without reinforcement. Today, I will share Taiwan's experience. As you may or may not know, Taiwan is not a member of the UN system, and therefore, we cannot formally sign most human rights protection treaties. The constraint is fundamental, but the pathway is not blocked. Taiwan's people and the lawmakers have built a route to institutionalize soft law and gradually harden it. Let me give you an overview of Taiwan's pathway. It involves 5 steps that progress from soft law to institutionalization and ultimately toward hard law. Step 1 involves the domestication of core human rights treaties. Step 2 is to conducting quasi-international reviews at home. Step 3 is establishing standing mechanisms with a clear division of ministerial labor. Step 4 is turning principles into action plans and KPIs. And finally, step 5 involves institutionalization, international dialogue, so that external expectations are reflected in domestic reform. Next, I will take you through each step in more details. Step 1. We bring international standards into the house. Although Taiwan cannot formally accede to UN treaties, we proactively domesticated the core human rights instruments, including ICCPR, International Covenant on Civil and Political Rights, ICESCR, International Covenant on Economic, Social, and Cultural Rights, CEDAW, Convention on the Elimination of All Forms of Discrimination Against Women, CRC, Convention on the Rights of the Child. CRPD, Convention on the Rights of Persons with Disabilities. And we are ongoing efforts toward the Convention Against Torture, CAT. Through legislation or implementation acts, we incorporated procedures that require referring to international interpretations, reviewing and amending inconsistent domestic rules, and submitting national reports, thereby giving these instruments real effect in Taiwan. This is the first key move in hardening soft law. Step 2, we bring review home. Taiwan submits regular national reports, publicly invites international experts to Taiwan for open reviews and a dialogue with the government, and incorporates civil society shadow reports. Reviews conclude observations and recommendations, which ministries are required to address and follow up on. This is not a formal UN procedure, but it delivers transparency, participation, and accountability. Although not under the UN system, we reproduce its functions: scrutiny, debate, conclusions, and follow-up. Step 3, we make the system run on institutions, not personal enthusiasm. In addition to the cabinet-level human rights coordination, the Taiwan government established the National Human Rights Commission on August 1st, 2020. That's 5 years ago. The National Human Rights Commission serves as an independent body for investigations, policy recommendations, and education. It's the hub for interministerial coordination and external engagement. Step 4, we turned principles into assignments. Taiwan grants abstract principles through thematic action plans. First, the National Human Rights Action Plan sets priorities and concrete measures with the requirements for openness, measurability, and periodic review. Second, the National Action Plan on Business and Human Rights, NAP, based on the UN Guiding Principles on Business and Human Rights, UNGPs, promotes corporate human rights due diligence, grievance mechanisms, and supply chain governance. This is continually updated and strengthened. This step ensures that soft law is not just a slogan, but becomes an annual plan, a ministerial division of labor, and budget items. Step 5, we bring external feedback inside. Since 2018, Taiwan and the European Union have held regular human rights consultations. As you noted, the most recent one was on June 9th, 2023 in Brussels. Topics include migrant worker protection, business and human rights, gender equality, and more. These dialogues are more than just an exchange of information. They feed international expectations back to domestic policy updates and legislative reviews, creating a continuous loop. So you see these 5 steps. Why it works? We call it the twin engines of soft law and hard law. Soft law excels at speed, flexibility, and the first mover pilots. For emerging issues such as migrant worker rights, human rights risks in supply chains, and the digital rights, soft law can help initiate action to build consensus and establish practices. Hard law provides stability, predictability, and enforceability. Once society has reached consensus and a clear path, we formalize it in statutes, regulations, and standard operating procedures, thereby securing accountability and continuity. Taiwan's experience is to start with the soft law and anchor it with the hard law. Principles and the dialogue come first. Effective practices are then institutionalized and legalized. These two are not opposite, but twin engines. Finally, I'd like to provide 3 repeatable moves. It's a suggestion. Suggestion 1, we make a review a system, regular review, public sessions, shadow reports, conclusions, and follow-up. All of this help us identify trends, address issues, and foster improvements. Suggestion 2, no KPI performance indicators, no continuity, no budget, no execution. So integrate soft law into the administrative mechanism so that principles become part of daily work. Suggestion 3, mechanisms like the Taiwan-EU consultations are not diplomatic courtesies. They convert external regulatory trends into a domestic reform to-do list. When the concrete cannot be built, we make transparency, participation, review, and follow-up are rock solid. When treaties cannot be signed, we import international standards, write them into law, turn them into procedures, and quantify and quantitate them as KPIs. We hope that Taiwan's experience can send you a message. Between principles and enforcement, we can choose twin engines. Between soft and hard laws, we can choose complementarity. Thank you for your listening. Thanks.
This was Jason Wu, Vice President of Taiwan Bar Association, who has shared different new concepts with us. And to begin with that, I must say the 5-step formula which was introduced by our Taiwan Vice President, that is really something different. This was an addition to what our first speaker Rajiv contributed. Rajiv pointed out about Sri Lanka, then the Taiwan contributed and pointed out that how this can be introduced in the national laws or the domestic laws. And he has also pointed out that the National Human Rights Commission of Taiwan is taking active lead in implementation of this human rights and converting the hard law into soft law. Now there is a little change in the printed program and the today's speaker. In the printed program, we were supposed to hear the President of Association of Mongolian Advocates. The President is Danzarao Lakhova. I'm sorry, I may not be correct in pronouncing that. but he is there and he has deputed his another participant. Here, the today's speaker is Mr. Anar. Mr. Anar is going to share with us the thoughts as per the direction given by the President of Association of Mongolian Advocate. Before Mr. Anar starts, let me introduce the President. The President, something interesting which I found is this. Even now, the President of Association of Mongolian Advocate is a student. He has registered himself for Doctor of Juridical Science program in the year 2019. Let us give a big hand for the President of Mongolian Advocate. And Mr. Anar, his representative is concerned, he started his career in the year 2010 and now he is in charge of foreign relation so far as the Mongolian advocate is concerned. Now the floor is yours, Mr. Anar. You can start.
Thank you very much. And I'd like to, it is my great pleasure and excitement to speak in front of our dear, esteemed and special guests who hold high posts in their respective jurisdiction and also in legal community network, to share some informative ideas on the given topic of the hard and soft law and have your valuable opinions and inputs for our joint session. I thank Mr. President Danzanoro and our ex-president Mr. Batsukh and all the colleagues from Mongolia for the peer review and support. So the first slide shows how we usually view the difference between soft law and hard law. So we see hard law as a binding, compulsory, top-down, clear and strict application, and more official, and within the nation state and the international treaties, centralized, vertical style, independent, traditional and conservative, have slower responses, and subject to sometimes loopholes and gaps and voids. And we see soft law as non-binding, voluntary, bottom-up, blurred and flexible application, more organic with grassroots engagements and beyond the nation state and usually transnational, and more decentralized and horizontal style, interdependent, novel and reformative, and could have higher response, and the source of customary law can address loopholes and gaps and voids. So since we all know about the issue we are discussing here, and our purpose of our discussion is to examine how certain questions raised will be relevant to us. So I would like to present three cases relevant to Mongolian, but also into international institutional frameworks that might be interested to you. So first case is the interim free trade agreement between Eurasian Economic Union and Mongolia. So Mongolia has a free trade agreement with Japan. As we all know, Japan and Mongolia entered into economic partnership agreement. So this is the first free trade agreement. But now our second free trade agreement is being made with the Eurasian Economic Union, consisting of Russia, Belarus, and other Central Asian countries. So this interim agreement has not yet been passed by the parliament, but the government had already signed it, giving us near to zero reductions of tariffs and taxes in terms of a number of goods and products. So we see the elements of soft law and also the hard law in this free trade agreement, because when the first initiatives of this free trade agreement was echoed during 2015 and 2020. So during that time, it was only at the level of declaration and joint statement that the both parties wanted to have a free trade agreement. So during that time, it was only a soft law. So based on those, during those soft law time, there were working groups and so many guidances and statements, number of statements, and then now it became formulated into a more hard law treaty, but still, as we can see from the name of the agreement, it's an interim agreement, and it's also serving as a semi-hard law and soft law legal instrument, because within this agreement we have certain clauses where the next phase of the free trade agreement will be also discussed, and so parties will be aspiring to have a more deepened relations in terms of trade facilitation. So, for example, the hard law elements of this free trade agreement covers about tariff commitments and duration and renewal of clauses and ratification process and requirements and quantitative obligations for the trade. And soft law elements will be saying about the non-tariff cooperation, strategic aspirations, for example, to have a more broader economic cooperation for future integration of economy, and market access and promotion, which do not necessarily obligate both parties in a hard way, but gives a statement about their aspirations. So we have at this moment we have many similar soft law instruments with the United States, with the European Union. So we can also expect similar this kind of like foreign trade agreements in future if those soft law instruments can be converted or successfully negotiated as a hard law legal instrument. So what we can observe from this interim free trade agreement is that this was actually a result product of first memorandum of understanding, and later from joint declarations of the working groups, and then it became a hard law instrument with a real impact. So by serving as a preparation for creating hard law in the future and providing cooperation mechanisms and formulating organic visions and ideas regarding the state commitment into clearer and more technical legal solutions, these software elements and software law instruments became now a hard law instrument. So we can see a very unique, some kind of like a reproductive relations between the hard law and soft law in this, by this case of free trade agreement. So next case that I would like to call your attention to, which we thought might be a little bit interesting to you, is that the Mongolian case of a notary, where the domestic law, where we can see an interaction between a domestic law and also soft law principles laid out by the International Union of Notaries. So Mongolia is a part of a civil law system that follows the continental model of notary system and Latin type notary, and we have our domestic laws based on the model law of notary, and notary law was adopted in 2000 revised in 2011 lately, and some additions were made also after that, and it sets out the core principles of the notarial works and legal status of notaries. And but there are some areas where notary law is silent, and where the principles of international union some certain documents is more clear and more efficient in terms of seeking solution to legal matters. So the example is that when a notary provides a certificate of inheritance to the children or to the descendants of the deceased person. In some cases, there can be cases where falsified documents or other types of evidences can be used to trick the notary and get the inheritance certificate or forgery of signature. But unfortunately, the current notarial law itself is a little bit silent on that. It would require like a lot of criminal investigation and those processes that might, or civil processes that might take long. But there is only a very vague clause in Article 28, point 2.1, where notary law says that the client is obligated to accurately prepare the documents for the notarial acts and to be responsible for it. So there was one case where that the notary was, obliged to provide the inheritance certificate, and later found out that certain documents was falsified documents. And in that case, a notary referred to the International Union of Notaries documents, which says that in the principle of notarial function, in the part 3, which says about certain duties about how the notary should ensure the non-contentious matter of the notarial acts. So that was not an official source in the domestic law, but it was the soft law instrument. And in that case, one Mongolian, Southern Mongolian court on June 9th of 2025 reconciled the case between the claimant, who is individual, and the respondent, who is a notary, using the International Union of Notaries principles to interpret the national law, which is a little bit ambiguous and vague in terms of the clear application of the issue. So we see in this case, we see how the general principles of lawfulness, fairness, and strict adherence to ethical rules applicable to notaries' activities under the domestic law and also under the International Union of Notaries can be effectively used to solve certain disputed matters in a very efficient and in a very time-saving way. So what we can observe from this is that this case has been praised in the legal community as a very progressive case because it is viewed as a sophisticated practice of upholding rule of law and human rights protection through not only through hard law but also accepted soft law principles. So we can also see similar soft law instruments. For example, United Nations basic principles on the role of laws, and in terms of the judges, we know that Bangalore principles of judicial conduct, and for not only for the legal profession but also for the other profession like accountants. There's a chartered financial analysts network who also have their own mechanisms and governing bodies, but they have a more international or regional or transnational standards and jurisdiction through the membership or through the personal jurisdiction. So we can see from this case that if a soft law, the soft law can be used as a very reliable resource to make progresses in the legal service and judicial assistance as well. And the last case is also a very important case, interesting case, because it covers about when a solution where there was no national standard in relation to certain highways and certain complex infrastructure projects, and during that time the public bidding of that infrastructure projects have been made, and so in order to find a solution, the clause of good engineering practice was introduced into the contract. So there were no like actual standards in the Mongolian territory, but we had an entitlement to that soft law clause by doing that. And also we used the FIDI contract of form in these major high value contracts as conditions of contract, which were not actually allowed by the public bidding law. So government provided a specific ruling to use the FIDI contract. So so in conclusion, I would like to say is that there is soft law can be used as a reliable tool, and it has both soft law and hard law can be transformative between the two parties. And I think it is this interaction where the creativity of lawyers can be tested and experimented to reach to the progress. Thank you for your attention.
This was our Mongolian brother, Mr. Anar, who was representing his president. And he shared 3 different cases and pointed out how Mongolian experience is there. And most important was about the notary and the lawyers, because there's a gathering of the legal experts. And most appropriately, he pointed out that role of lawyer in Mongolia, then the basic principles, and we felt proud when you made a reference about the Bangalore principles of judicial conduct. After having shared with this, he pointed out that how the Mongolian experience is there, how they have implemented their soft law into hard law so far as the contracts are concerned. Thank you, Mr. Anar. Now there is a 4th and the last speaker. Now our last speaker is a president-elect of the Law Asia. When our present president is in front of us, Advocate Shyam Diwan, senior advocate from the Supreme Court of India, the president-elect is on the dais. He is from Singapore, and in 1991 he was admitted to the bar of England and Wales. So he started from England and Wales and then shifted to the Singapore. And apart from practicing in the cross-border disputes, divorce, international child abduction, apart from that, he is known as a collaborative family practitioner. He is accredited mediator also, the parenting coordinator also, and senior international mediator. Now it's a time to call upon Mr. Liang, President-elect Law Asia, to share his thoughts. The floor is yours.
Thank you, Mr. Uday, for the kind words of introduction. I would also like to thank Mr. Prashant Kumar, President of the Bar Association of India, and the BAI for the opportunity to share the stage with my esteemed colleagues on this session. I think, to be fair to Mr. Shyam Diwan, he did not ask me to present this. And that's the problem with volunteering, right? Something you never knew what it was about actually when you first said yes. But on the topic of today's discussion, the protection of human rights extends beyond treaties which are legally binding and agreements, principles, and guidelines which are not legally binding. Soft law in some cases are the precursor to the development of hard law norms. Many international human rights treaties have been preceded by soft laws, which covers declarations on the same topic. That said, enforcement of breaches of human rights violations continue to pose challenges within the domestic front as well as the international community. Enforcing human rights treaties is challenging due to the state sovereignty, lack of political will, weak international enforcement mechanisms, but effectiveness may be enhanced by national implementation mechanisms, oversight by international treaty bodies and the courts, individual complaints mechanisms, and the indirect influence of monitoring and reporting. While direct sanctions are rare, pressures from reports, public opinion, and the growing body of human rights law can guide states towards compliance and improved practices. The Universal Declaration of Human Rights of 10th December 1948 is widely recognized as having inspired and paved the way for the adoption of human rights treaties, applied today on a permanent basis at global and regional levels. Building on the achievements of the UDHR, the International Covenant of Civil and Political Rights and the International Covenant on Economic, Social, and Cultural Rights entered into force in 1976. These two covenants have developed most of the rights already enshrined in the UDHR, making them effectively binding on states that have ratified them. They set forth everyday rights such as the right to life, equality before the law, the rights to justice and fair trial, freedom of expression, the rights to work, social security, health, and education. Some of the treaties which have come out of the UDHR, for example, are the Convention on the Rights of the Child, Convention on the Rights of Persons with Disabilities, Convention on the Prevention and Punishment of the Crimes of Genocide, Convention on the Elimination of All Forms of Discrimination against Women. The challenges that have posed covers some of the following. Where the lack of political will, for example, is concerned, states may prioritize national interests, such as economic or security concerns, over human rights obligations. Weak enforcement power is another challenge, and international bodies often lack direct enforcement powers, making their influence actually contrary, more indirect. International law relies heavily on the consent and cooperation of states, which can limit the authority of international bodies. So one can see the tension that is developing or has developed and will continue to develop. May I now turn to soft law and the UN Guiding Principles on Business and Human Rights of June 2011. These guiding principles are grounded on three pillars: the state's existing obligations to respect, protect, and fulfill human rights and fundamental freedoms, i.e., the government to protect human rights. 2, the role of business enterprise as specialized organs of society performing specialized functions required to comply with all applicable laws and to respect human rights, which means companies are now also to respect human rights. And the third pillar, the need for rights and obligations to be matched to appropriate and effective remedies when breached, which means victims of corporate abuses to have access to effective remedies in law. Guiding Principle 25 of the UN Guiding Principles on Business and Human Rights states, as part of their duty to protect against business-related human rights abuse, states must take appropriate steps to ensure through judicial, administrative, legislative, or other appropriate means that when such abuses occur within their territory and or jurisdiction, those affected have access to effective remedy. And Guiding Principle number 26 provides that states should take appropriate steps to ensure the effectiveness of domestic judicial mechanisms when addressing business-related human rights abuses, including considering ways to reduce legal, practical, and other relevant barriers that could lead to a denial of access to remedy. An article by Juan Jose Alvarez Rubio and Caterina Yanibas have noted that such barriers may include the lack of jurisdiction by the courts of a particular state, questions of which law is to be applied, absence of duties of care on the parent company, availability of legal funding and representation, and many others. Overcoming these barriers require states to conduct an assessment that will provide it with a clear view of which barriers are problematic in their own legal systems and what should be done to have them eliminated. The European Coalition of Corporate Justice has noted that the EU lacks coherent and comprehensive policy framework to ensure businesses respect human rights. Victims of abuses have to wait years for justice, but to no avail. Corporations can wreak environmental and climate change without serious repercussions, and we do continue to see that in today. Not all EU states have their own action plans. Almost half are lagging behind with no regulation, instead of relying on voluntary action by businesses, hence no oversight. Victims must have recourse to companies which should be held accountable. What then needs to be done to try and overcome these challenges, and what is the way forward? The global reach of transnational businesses have significantly increased over the past 30 years as a result of liberalization of international trade and investment. Yet the conditions under which these businesses may be held liable for human rights abuses have not aligned with this evolution. States have, in general, failed to fulfill their duty to protect human rights by ensuring that victims have access to effective remedies, including judicial remedies, particularly for human rights abuses that occur abroad, extraterritorially, at the hands of businesses. This resulting lack of access to judicial remedies provided by home states for human rights abuses by businesses, in particular, those abuses that occur extraterritorially, has a considerable impact on the effective exercise of human rights. In host countries, host in inverted commas, where corporate abuse often occurs, victims can face barriers associated with weak rule of law and corruption. The inability to enforce court decisions is equally significant. Even when justice is served, the problem is that there is no way of enforcement where corporate culprits have their assets. When attempting to bring cases against companies before the home courts for harms committed abroad, the victims also face unique procedural and substantive barriers, which are often insurmountable. Just to give an example, you may remember the Royal Dutch Shell case, in which lasted almost 13 years and demonstrates how difficult it is for victims of harm to obtain justice. A key barrier to that case was the corporate veil, a corporate shield against liability for human rights abuses by a subsidiary company. In court, the oil giant had argued that it was not responsible for the oil spills, which happened in Nigeria, which affected 40,000 Nigerians, and other violations committed by the Nigerian subsidiary. It is exceptionally difficult for the plaintiffs and their lawyers to disprove, as it required significant disclosure from parent and subsidiary companies, and such information, as we are all aware, are not readily divulged. This exemplifies how parent companies use their subsidiaries as a shield against liability for human rights abuses occurring in their corporate group. In around April of 2020, Didier Reynders, the European Commissioner for Justice, had announced that he would propose some human rights and environmental rules for companies. Now, to prevent further tragedies, there ought to be administrative, civil, and criminal liability for corporations with serious penalties for those failing to comply. This would not only incentivize companies to do better, but it's also the only way to provide grieving, traumatized, and injured workers and their families a much-needed path to justice and compensation when companies fail to prevent abuses. Digressions from hard law would presumably generate more shame, as the company would be a breaker of international laws. Digression from soft law norms by companies attracts attention from civil society and media, and therefore a degree of shame and brand damage. In conclusion, there's much work to be done, both at the state level and in the international arena. The issues are not confined to this part of the world, but is international. Perhaps, if I may respectfully suggest, that the following may provide a starting point for enforcement, which is ultimately what this is all about. Legal precedent and the body of decisions and interpretations from treaty bodies and the courts will help to clarify and apply international norms to real-world situations. On the domestic front and implementation, when treaties are incorporated into domestic law, their provisions become directly enforceable in the national courts. What about international pressure? Monitoring, reporting, and the threat of international condemnation can influence state behavior and encourage compliance. Public scrutiny. Reports from treaty bodies and NGOs, along with media coverage, can raise public awareness and subtle pressure on governments. It is with those thoughts that I leave you for this morning's session. It certainly raises more questions than answers. And on behalf of my panel, I'm sure they agree with me, the answers really rest on political will of the governments. So please direct your questions to the right people. Thank you.
Fantastic. And in the conclusion, what our brother said from Singapore, that is more relevant, because ultimately the political will is more required if you are going to implement those international treaties and covenants. Mr. Yap Liang from Singapore, he shared with us how these human rights in the business practices can be introduced. He also shared with us the state action plan which should be there. He also made a point that companies should be held responsible for the breach of human rights, and also he gave a red flag saying that there will be international pressures, and therefore now before all of you ask a question, there is a one question, single line question to all 4 panel members, and that question is, ultimately we are lawyers, we are students of law. In our different jurisdictions, we have seen how soft law and hard law have been implemented for years together. So let me ask that common question to all 4 panel members. The first is Sri Lanka. The question is, what about the human rights of the lawyers and how you have implemented these different principles in the Sri Lankan context? The same question will be thereafter to Mr. Jason, who will share from Taiwan experience, then Mr. Anar from Mongolian experience, and then the President-elect of the Law Asia. He will be speaking about this particular topic, namely how you are looking at the human rights of the lawyer. Rajiv.
Thank you, Dr. Uday. It's an interesting question. So from the point of view of the Bar Association of Sri Lanka, one could possibly say the Bar Association in Sri Lanka is the most influential civil organization in the country. So therefore we wield a lot of influence in what takes place. We have 92 branches across the length and breadth of Sri Lanka, 65,000 square kilometers, and we have lawyers everywhere. So if there is any problem the lawyers have, we are a formidable force. Now, if the principles governing the Bar Association vis-a-vis lawyers and of course the citizens is principles of rule of law, due process, the independence of the judiciary, human rights, and of course the wider rights and interests of the lawyers. And so if there is any point where we see that there is some infringement, curtailment of rights of lawyers, whether it's human rights, whether it's beyond, then the Bar Association would intervene. Of course, we draw the line in this way. We intervene positively when it has to do with professional duties and professional work. If you have lawyers engaged in other occupations, say even politics, and then we are a little careful on intervening and limit it to the professional duties and of course the general rights as citizens. Now there was an interesting incident which took place. I took office on the 29th of March, as I mentioned, as president of the Bar Association. That was a Saturday. And I had the convocation, a large event, where I was inducted. The day before, there was a lawyer in the Puttalam High Court, that is about 3.5 hours from Colombo, a lady lawyer. There had been a dispute between the lawyer and the judge for a little bit of time. And somehow on that day, she was remanded for contempt of court on the basis, one of the charges was that she had not bowed to court. And of course there were also the disruption of court and so on. Basically that was the crux of the charges. When she was remanded, I was not president, of course I was informed. I took office on Saturday evening at some of you who had come to Sri Lanka know, the BMICH is the largest conference hall. In the morning on that day, we had the first Bar Council meeting and one member raised this issue, a couple of members raised this issue. And anyway, we were apprised, I had received the call the previous day. And it was also a long weekend, it was a Ramazan weekend. It was a long weekend, and Puttalam is a district where there is a larger Muslim population, so a lot of administrative work stops. Another issue which came up was that though the judge had imposed bail conditions, the conditions are very difficult and impractical to satisfy at 12:30 in the afternoon. It was not simple conditions. So it was physically not possible. She was remanded. So on Saturday when I took office, she was remanded. What do we do? So it was Saturday, Sunday, and Monday were all holidays. We filed papers. We decided, the first act I had to get involved with, we decided to file a writ application, habeas corpus, and to combine with a certiorari and prohibition, challenging the judge. The judge was one of the first responded. The charge sheet and the order of the judge remanding on forced bail conditions and having taken this lady into remand custody. We made a request of the President of the Court of Appeal. I spoke as President of the Bar Association and requested that the court be opened on the Ramazan day. The President of the Court of Appeal was a Muslim. He was Muslim by religion, but he agreed to my request, and he convened the Court of Appeal on a public holiday on Monday. So the papers were tendered to the registry just before. The Attorney General also sent in a representative on our request, because the respondents had to be represented. And I was the petitioner in the case as President Bar Association. We had a team of members who went in and supported the application. And notice was issued and a stay order was issued, staying the remanding of the charge sheet and the consequential decisions. Then of course as President, and there was also concern whether, since it is a public holiday, even though the order was issued, whether it will administratively take place at the prison to release her. So given that it was one of our members, I traveled to the prison and went and met the superintendent of the prison. We carried the order and she was released. So that is the type of intervention we do in respect of rights of lawyers, human rights of lawyers.
Thank you, Rajiv.
One of the members from the Bar Association of Water Council wanted to say something against.
Can we take his question after 3 or 4 minutes? There are 3 more speakers. They will speak on this topic. Jason, your experience about protecting the rights of the lawyer.
Okay. The basic norm for lawyers in Taiwan is the Attorney Act. It was enacted in 1941 and was overall amended in 2020. No matter the original one or the amended, the Attorney Act upheld the autonomy of lawyers. That means self-regulation. So, all lawyers, practicing lawyers, are mandatorily to be members of the Taiwan Bar Association. It was established after the 2020 amendments. And in addition to the requirement that each practicing lawyer must be a member of a local bar. So, I think that the very important part is that we say the autonomy of lawyers. I think that's the concrete base to protect the basic rights of lawyers. As for the lawyers' rights, basic rights for our practice, especially for criminal proceedings, these lawyers' rights are enacted in different procedure acts, Criminal Procedure Act, Civil Procedure Act, Administrative Litigation Act. All of these proceeding legislations clearly promulgate the attorney's rights, and especially for criminal proceedings. At first, when a person was interrogated by the police, he or she had no right to seek the assistance from the attorney at first. Then later, we extended it to, okay, so during all investigation procedure, from the police to the prosecutor's office, every stage, each person can find attorney to protect her or him. It was, that's the endeavor of, from many lawyers to make this happen. And there are several cases happened when attorney practice tried to protect her or his client, but was stopped by the police or by the prosecutor. And for these cases, we bar support these attorneys to file suits and even file to plead to seek the constitutional court's explanation and decisions. And so now we try to make it concrete and expand lawyers' basic rights to protect clients, especially during the criminal proceedings, especially before the court hearing procedure. These are, we say, maybe hollows, like the topic we say today. These are hollows. And as for the soft laws, we have local bars and the national bar, the Taiwan Bar Association. And for each local bars, they annually has the exchange meetings with the district court and the district prosecutor office. Exchange opinions, and we also raise some issues for our practices, so that the problems, some problems can be resolved in this kind of exchange meetings. And in national level, with Taiwan Bar Association, we also have annual exchange meetings with the judiciary and the Ministry of Justice, respectively. So these are, maybe we can say, soft laws. Like this way, we can resolve some practicing issues through this kind of meetings. This is Taiwan's experience.
Thank you, Jason. Now let us go to Anar in a quick, maybe 1 or 2 minute, how human rights of the lawyers are protected in Mongolia.
Okay, so in Mongolia we have also Attorney Act ratified by the Parliament in 2019, and similarly to Mr. Rajiv said, and similar to Mr. Jason Wu said, it's an unified membership organization, independent professional union, self-governing body. We do not have any composition or delegates from the Ministry of Justice as comparable to some of the jurisdictions. And there are certain sufficient legal guarantees provided under the law. So also there is a code of conduct for professional activities has been also been released, approved by the Mongolian Bar Association. And also in criminal code we have protections for the attorneys to have immunity against investigation, to sustain their lawyer-client relationship privilege and other secrecy requirements. And also, interestingly, we haven't yet practiced this legal potential, but Association of Mongolian Advocates is entitled to bring claims to protect the interests of individual, to common and individual interests of the attorneys before the court if they deem necessary. So it's, and also, sorry, very few, that might be interesting is that there has been a latest case where I served as attorney for the lady attorney, and she was, she received a disciplinary penalty for, being blamed that when the case was not yet resolved finally, she made a public statement against a beauty clinic who made an omission during surgery and caused the blindness to the client. And she made certain warnings to the public that you should be careful about receiving the service of this beauty clinic. But then the disciplinary penalty was annulled by the court, and during the court, that court decision accepted, recognized the attorney as a human rights activist. So we have a new law as well on the protection of human rights through human rights activists. So in Mongolia, the lawyers became officially human rights activists. Yes.
Thank you, Mr. Anar. And let us go back to the President-elect, Mr. Liang from Singapore.
Thank you. Well, when we talk about human rights for lawyers, we go to the UN Basic Principles on the role of lawyers. And Law Asia, if it's brought to our attention, or from bar associations in which lawyers face persecution, harassment, for example, then Law Asia does assist our bar association members to issue statements protecting and to the governments, protecting the role of lawyers. But linked to this, we must also appreciate that there's also the rule of law. And from the larger international organization perspective, this is one of the points I made earlier when I shared, right, on the international community coming together and putting some pressure on the local domestic governments to seize the actions which may affect human rights violations against lawyers.
Okay, thank you. Now the Bhutan brother wanted to ask some question. We have some time, around 5 minutes we have. Please ask, introduce yourself and ask question.
Good morning to everyone. I'm Sonam from Bar Council of Bhutan. Thank you so much, the esteemed panelists, for giving a very insightful talk about the soft laws and the hard laws to deal with human rights. I felt like I'm not doing justice to my jurisdiction if I don't contribute with any kind of comments. And then as well as I have a few questions, which is also very related to the question that is asked by the moderator. To go with first, even from my perspective, I feel like the hard law and the soft law have to go in line with to achieve any any objective that you are looking for. If I give an example in Bhutan, like I have personally shared with so many of you, Bhutan, the Advocates Act of Bhutan only came up in 2003, and then nothing much could have done. Yet the country was evolving with evolving with the world around. And then in 2017, we have amended 2016, we have amended the Advocates Act of Bhutan, where we call Jabmi Act. Jabmi is the term in Bhutanese language meaning advocate. And then from 2017, the official establishment of Bar Council of Bhutan came up. And that, also before that, when it comes to the equal representative and then the right to attorney for the individuals who are tackling with the cases. Though our constitution provides that right, but the representative of lawyers was not at all there in the market. So it came up later on, and then that was also like maybe because of the soft laws and the international treaties, human rights, because of that force that we have come up, and then we are now I think in a good position to represent any kind of client that that come up to us. And now my concern and my question here is related to the question that is being put in by the moderator. Here, like when it comes to the protection of lawyers, though we don't have much number, in number, it's not a big number in Bhutan, yet we are not free from any like the problems. So when it comes to hard laws to protect the attorneys in Bhutan, we also have like Attorneys Act, Code of Conduct, but all these laws only talk about what are the responsibilities and duties of lawyers. It doesn't talk about how the lawyers are going to be protected from the external forces and the problems and issues that are being faced by the lawyers. So, like you said, we also have a culture of conducting annual general meeting, calling the stakeholders and sharing our issues and problems to help us solve that. Now, my question to the panel is, where does the authority of the Bar Council or the Bar Association come to challenge the actions of other authorities, other authorities' actions against the lawyer? So, if you could share any insight on that.
Thank you, brother from Bhutan, maybe the youngest bar council. Law is well settled about that, and the bar association or the bar council gets a locus. There is no difficulty, you can challenge the action. Let us go to that young man who want to raise. Yes, the mic, can you pass on the mic or start, please? We are having hardly around 3 minutes. Please try to ask us a short question. You can take this also.
Thank you, Uday, and distinguished panelists. Me Kedar from Nepal Bar Association. Nepal Bar Association has the 4 pillars. Among the 4, human rights is the 1 pillar. Nepal is one of the Asia Pacific regions, one of the country which ratified the international instrument. Among the 9 core instruments, 7 are ratified by the country. In our constitution, in the fundamental rights, most of the soft laws are adopted, even though we have the problem of the enforcement. In principle, we adopted the international instrument of the human rights, but in enforcement, we cannot do that principle in practice. So, in Nepalese context, Nepal Bar Association plays the vital role in the protection of the human rights in the kingship's tyranny period, and in the freedom of press. And Nepal Bar Association legal community, it appeal from the judiciary side many strictures and orders on the issue of the human rights issue. Now we have the questions about the National Human Rights Commission is preparing the human rights defender law. How can we make the human rights defender law? If we have any experience in the Asia Pacific region or international region, can you answer this?
Yes.
Queries?
The brother from Nepal has asked a relevant question, but my time is short. Our session will end within 2 minutes.
Thank you.
Let us meet in the while having a cup of tea. Yes, brother. The last one.
All right,
I
Jose
think
Morley, Hong
they
Kong
can
Bar
extend the
Association.
session by a few minutes. I am the next session, so you can take my session, few minutes from my session.
Yeah.
So it's okay.
Rachana
We
madam
have-
is kind enough to give us
we
5-minute
have fewer-
extension.
We have fewer speakers, so it doesn't matter.
Okay.
Well,
Let's
thank
Yes,
answer
we will try to
I'll
cover
just
up
be
that
90
Nepal.
seconds
I
anyway.
also have a question.
Oh my God.
I'm
Yes,
Jose
brother.
Morley, Hong Kong Bar Association. I think in terms of hard law and soft law, one important feature we should remember is not so much what the rules are, but the mind and spirit of the people who apply them. And therefore, what is also very important is the DNA and culture of those who are entrusted with power. And in that regard, I thought it was quite inspiring. About 15 years ago, we had a director of public prosecutions in Hong Kong, who during the time he was in prosecutions, actually did a master's in human rights. And when asked, well, why are you doing this master's in human rights? He said, well, in this time and age, if you want to be an effective criminal lawyer, you need to understand human rights. And I think this goes for every executive in every jurisdiction. In other words, that whenever you exercise your power, it's not because the rules constrain you, but you have that mindset that you take into account other people's rights and responsibilities. Thank you.
Fantastic. This is a contribution from Hong Kong. Anybody? The last will be Rachana madam, but anybody want to add something? Of course, these are the takeaway which we will have to carry and ponder on those different issues. Nobody? All right. Rachana madam.
I don't have a question, but I want to share one experience similar to what Rajiv Amar Surya had said just now. It's a recent experience. I was at that point of time the vice president of the Supreme Court Bar Association. There was a case where a lawyer had filed a petition. He had e-filed it. The Supreme Court permits e-filing, and also hybrid hearing is also permitted, so you can appear virtually from any corner of the country. So he had filed this petition, especially petition challenging High Court's order. Incidentally, he had filed second petition challenging the same order, but he had disclosed that in the petition. Now when the matter came up for hearing, so the judge found that this order has already been challenged. Although this was registered, it was the duty of the registry to point it out. But since it was registered and placed for hearing, court asked for the lawyer. The lawyer incidentally was far off in some south district. The internet was not working. So when the court asked for the lawyer, he was not available. The instructing counsel who was appearing physically said he's at a remote place where the internet doesn't work always, but I will convey and he will come back at 2 o'clock after lunch. Judge agreed, but the matter was not called, and he was online at 2 o'clock. Anyway, next time the court issued notice and asked him to appear with his return tickets from wherever he is. So court was under the impression perhaps he is in the town, but he's not appearing, he's avoiding the court. So when this order was passed, it's very interesting. So we could apprehend something is coming. So the lawyer came with his tickets, and he showed the tickets and he apologized, everything. The judge was furious. And then it was a division bench, and the judge, incidentally a lady judge, she started dictating order for contempt of court, criminal contempt of court, directly, without issuing notice, without seeking his explanation. So then I appeared, I intervened. I said, Lordship, where is the rule of law? Where is the principle of natural justice being followed? You have not issued notice to him. You have not sought his explanation. You are directly implicating him for contempt of court. Court said, no, nothing doing. It's all there, nothing, you cannot. But I insisted, just give him one opportunity. And then other lawyers also joined, and they all insisted that one opportunity should be given to him. I said, we are not interfering with the merit of the case. You decide on merit, but give him one opportunity. After much persuasion, judges agreed, and he was asked to submit his explanation. And when he submitted explanation, he tendered his apology. He said, although this fact was disclosed in the petition that he had filed earlier petition also, but court was not accepting that, and they reserved the order. And then came the final decision, split judgment. One judge said, the lady just said, bar from few months, 1 lakh cost, and the other judge said, we believe in forgiveness. He has tendered apology. And these things do happen in this profession. So we accept his apology and we forgive him. There was a split judgment. Then the judge who had sort of convicted him, she retired, and the matter went to different three judges bench. And it was recently listed. They accepted the judgment given by the judge who had forgiven him. So that's how the matter ended. So we do have a role to play. We do intervene when this kind of incidents do take place in the court. So bar associations are not sitting idle. They do take up these kind of causes. There have to be a spirit. I'm sure the leaders all have that spirit to defend our colleagues. Thank you very much. Sorry, I took this longer time.
Thank you, Rachana madam. And now the concluding note. And I'll make a request to the President of the Law Asia, Shyam Diwan, to come up for a group photo with the panel speakers. The last sentence would be a last minute, 1 minute only, sir. This is a session which has given some input to all of us as to how that soft law can be implemented in our local jurisdiction. And the addition was about the protection of the human rights of the lawyer. I'm sure this must have cropped up different questions in our mind, and while having a cup of tea or while having a lunch, all of you can ask questions to the learned panel members. I'm really thankful to all 4 panel members and the organizing committee who gave this wonderful opportunity. Thank you. One more, please. Here, yeah. No, you should be here. Okay. Arey brother, ye le. Okay. Ye le. Okay. Thank you.
One more.
Oh, sorry.
Thank you.
Thank you, Mr.
Thank you, Uday.
Yes,
Thank you.
let us meet once again. Rajiv?
Yes.
Thank you. Thank you. Yeah.
Thank you. So now next one is yours.
Good morning. I request everyone to please come inside the hall. We are starting the next session. The session is AI in Legal Practice, Education and Litigation, Preparing the AI Lawyer Era. I'll just introduce the subject and then I'll call our panelists. Artificial intelligence is one of the most transformative forces shaping the future of law. Globally, AI has revolutionized legal practice by enhancing efficiency, accuracy, and access to justice. In India, where the judiciary is the guardian of a diverse constitutional democracy, but also faces a challenge of over 50 million pending cases, as per the National Judicial Data Grid 2025, the integration of AI holds particular significance. As we know, legal research is fundamental to practice, but the vast body of case law and statutes make it time-intensive. AI-powered research platforms use natural language process to generate context-driven search results beyond simple keyword matches. AI-driven contract lifecycle management tools can identify risky clauses, suggest edits, and ensure compliance with Indian statutory requirements. For corporate lawyers, these tools accelerate M&A due to due diligence by scanning thousands of documents, reducing time and cost. In a heavily regulated economy, compliance failure often lead to litigation. AI systems are being deployed to track updates from regulatory bodies like SEBI, RBI, automatically flag compliance gaps. Chatbots and AI assistant initiate client inquiries and improve efficiency. This provides legal access, especially for startups, individuals who cannot afford high legal fees. National law universities and other law schools in India are increasingly exploring interdisciplinary courses in AI, data governance, and law and technology. The Bar Council of India has encouraged law schools to update curriculum to address contemporary challenges, including AI. AI tools and case law analytics platforms enable students and faculty to map doctrinal developments. For example, AI can trace judicial expansion of Article 21 of the Constitution from way back A.K. Gopalan case in 1950 to Puttaswamy to 2017 with efficiency. AI-powered e-learning systems analyze students' progress, offering customized study material and mock tests. In India, where legal education quality varies drastically, such technology could bridge institutional gaps. The future of legal education must prepare lawyers not only in constitutional or commercial law, but also in algorithmic accountability, digital rights, and AI ethics. This shift is crucial for India to build a generation of tech-savvy legal professionals. The e-Courts Mission project, launched by government in India, has already digitized court records and enabled e-filing. Building on this, AI can support case management, scheduling, and reducing procedural delays. During the COVID-19 pandemic, the judiciary shifted to video conferencing. With over 1.25 crore virtual hearings conducted, AI can further assist by enabling real-time transcription and translation across Indian languages, critical in multilingual country. AI models trained on past judgment may reproduce existing bias. These are the concerns, whether gender, caste, or class related. If AI tools suggest erroneous legal advice or misclassifies evidence, who bears the liability? The software developer, lawyer, or the court? The accountability gap is yet to be resolved. The Digital Personal Data Protection Act 2023 provides a framework, but legal records, being highly sensitive, require heightened safeguards against misuse. Elite law firms can afford AI tools, while small practitioners may be left behind, widening inequality in legal services. Publicly funded AI platforms could bridge this gap divide. I believe that human empathy, constitutional morality, and discretion cannot be replaced by machines. AI must remain a tool, not a substitute for adjudication. So the way forward is regulatory framework to address transparency and accountability, capacity building. Judges, lawyers, and law students need structured training in AI literacy. Judicial Academy could integrate AI workshop. Government-supported open-source legal AI tools should be developed
to aid ordinary litigants and small firms. A human in the loop model should be adopted to ensure that AI recommendations are always reviewed by human decision makers. AI is poised to reshape legal ecosystem across the globe by making practice more efficient, education more forward-looking, and litigation more accessible. Yet, adoption must be cautious, preserving the human sense of justice, because AI should be servant of law, not its master. With these words, I will invite my panelists. Professor Dr. Vijay Prasad Mishra. He is the president of Nepal Bar Association. He is senior advocate. He has previously served as the Secretary General and Central Committee member of Nepal Bar Association. He has experience of over 35 years as a lawyer. He is a professor at Tribhuvan University Faculty of Law. He has been teaching legal system and Nepalese legal system at LLM level. Throughout his career as an academician and a legal expert, he has represented Nepal and international forums in various countries. May I request Dr. Mishra to give his presentation. You have a PPT here?
Yes.
Yes, please.
Thank you very much, Rochana, Vice President of Indian Bar Association, for kind words. All the panelists as well as participants from different jurisdictions, including Vice President, Secretary General, Treasurer of Nepal Bar Association, as well as President of High Court, Patan Bar Association, which is one of the largest bar associations of Nepal. My topic with this regard is known to you all: AI, legal practice, education and litigation, preparing for the AI lawyer era. With this regard, I am trying to incorporate introduction to Nepalese legal practice and education, existing digital tools for legal profession and education, status of AI policy in Nepal, the use of AI in legal practice in Nepal and its effectiveness, use of AI in legal education in Nepal and its effectiveness, cost and consequences of using AI in legal practice and education as seen from Nepalese practice, and finally ethical and other concerns about the use of AI in legal profession. So far as Nepalese legal profession is concerned, it formally came into existence since 1956. Currently, the profession can be divided in, professionals are divided into advocate and senior advocate, but residues of junior advocates called pleader and agent are also in being. Over 22,500 lawyers are licensed, and out of them approximately 750 persons are awarded senior advocate title, of which some are active and some are not. Around 8,000 practicing lawyers, even fewer regular practicing lawyers. Various universities are there to offer law course, including Tribhuvan University, Purvanchal University, Kathmandu University, Rajarsi Janak University, Pokhara University, Gandaki University, Lumbini Buddhist University, Far Western University, and other universities are offering BA, LLB, LLB, LLM, PhD, and other streams of legal education. Now, globally tools such as LexisNexis, Westlaw have been used as digital tools for lawyers and law students even before the surge of AI. But these tools have also made use of AI lately. The tools have been limited use in Nepal. Instead, Nepal traditionally restored to non-AI based resource repository, Nepal Law Commission for Laws and Rules, and Nepal Kanun Patrika and Supreme Court Bulletin for Precedents and Ratio Decidendi. With the source of AI, ChatGPT and DeepSeek have been partly useful for lawyers and students, but with limitations because of lack of language friendliness, not knowing the socio-legal context of Nepal. However, lately the unveiling of AI platform named Kanun Portal is being launched, which is expected to address the deficiencies of traditional research tools by incorporation generative AI tools for laws, precedents, and general legal questions. In relation to recent status of Nepal, on 18 August 2025, the government of Nepal has introduced National AI Policy. It has mission including increment of GDP by 1% at least. Not only this, increase in the ranking of AI readiness index to WIT 50 position, establishment of at least 5,000 human resources in AI area. In addition, establishment of AI excellence centers, AI literacy since primary education, institutional and legal reform of AI, promotion of use of AI in education, agriculture, tourism, energy, health, establish AI Regulation Council under the chairmanship of Minister of Communication and IT, addressing AI risk management. These are policies we have adopted, and the policies have just seen 11th day today, and how will it be implemented, it depends upon future course. In relation to particularization of AI utilization in across Nepalese lawyers, most lawyers of Nepal are not tech friendly, hence it has resulted in few lawyers using AI in regular usage and practice. Whether AI is helpful for creativity or whether it is destroying creativity or making person lazy is also under our consideration. But we are crystal clear that AI cannot replace humanity. AI has no human brain. Justice is delivered based on sensitivity, requirement, and circumstance of the people. Justice is religion. Justice is godly act. AI cannot replace that godly act. It is just auxiliary material. That is our understanding. And we are to be very much careful that it should not destroy or divert otherwise our sensitivity. We are always considering for the same. And we like to use our brain, hand, finger to write, to note, and to go ahead. But we have no other option than accepting it gradually. Earlier, people were walking, then they discovered motor car. After motor car was discovered, aeroplane system was also in being. People went in that path. Earlier, post office was only one method. Now, post office is partially serving the people. Email and other digital dimensions are being integral part of our life. We should also welcome AI following this same method. It is dynamic process, development process that we know well. But if we fully rely on digital devices, what would be future generation and our activity, we must think it properly. We are considering the same thing in adopting AI policy in real practice, so that what is its negative impact, we must pay attention. And use of AI has been largely limited to young lawyers due to being tech friendly. They are tech friendly, they dedicate their most of time in technology as well as devices. As a result, they are getting it as good opportunity. Also another issue, limited Nepalese legal data including laws, precedents, rules are available in English in updated version. Only few laws and rules are available. However, youth lawyers do make use of platforms like ChatGPT and DeepSeek for general legal opinions and mostly foreign practices and precedents. This has been especially useful in human rights laws. Previously, we used to turn the pages of law journals. We were to seek one precedent, but we were to roaming around other interesting precedent. Okay, other interesting precedent, and our whole day, whole hours were dedicated for searching new thing. One thing was searched, other things were found out, and it was also to increase our strength. Now that kind of tradition is going down because of AI. We particularize, we point out something, and that something is found out, we do not see other things. That is not being friendly for the healthy growth of our knowledge and mind. Anyway, this is unavoidable reality. Nevertheless, there has been marked attempt to create a full-fledged AI-based site for Nepalese lawyers named Kanun Portal to be launched next month, which could change the landscape of AI in legal market. Use of AI could also be explored in judgment writing. The problems with generic platforms like ChatGPT are hallucinations, wrong precedents, non-legal opinions, non-Nepali friendly, hence their use must be seen cautiously. With around 10,000 to 12,000 students studying law at all levels in Nepal, the use of AI is prevalent. AI has been of the use especially among urban BA, LLB and LLM students, from assignment writing to research to thesis and seminar writing. This has resulted in academic output being updated and more insightful compared to with AI. Incorporation of foreign practices has been increased. However, the use of AI platforms has been dismal in LLB and in areas outside of Kathmandu Valley. LLB is the degree offered to law graduates of other streams after they study law for 3 years. That is LLB degree. The students in LLB are not found out using AI. Now, lawyers may rely on precedents given by ChatGPT, which may be fake. Although such cases have not happened in Nepal, we have to be cautious about it. Like students are writing fake jurist opinion in their answer sheet. Sometime, okay, they may say, okay, teacher has not properly checked, I got passed, okay, even though particular person was not jurist, I presented him as jurist and I secured. Same thing is happening with this regard also. Use of AI may decrease the need to have to read multiple books and treatises for drafting and writing, but its depth can be questioned of, especially in the light of Nepalese socio-cultural context. Similarly, in academia, students' efforts have decreased to a large degree. This is important one. Students are not making efforts. If they are suggested to present term paper, they prepare term paper within short span of time. Okay, and we may feel it different, unnatural. Sometimes when we apply positive approach, we may see, okay, uniqueness also. But inside uniqueness, we are not finding out depth study, and this is being a serious problem in Nepal. Restricting AI is not an option, since it would essentially take us behind the times. Therefore, the optimal option would be to cultivate a personal thinking as to when to use AI and when not to. Ethical dimensions are also there. Copyright laws should be there. Minimization of plagiarism. Also there is, okay, it is not to substitute traditional learning. It is merely a complementary tool to enhance the quality of output. It is not it is just supplementary, not replacing tool. AI system may reflect biases also, there may be biasness. Somewhere I read out that there will be displacement of all devices like mobile, laptop, tab, when human beings keep something in mind, that would automatically happen by applying in some tools. That kind of devices are also developed. That somewhere I have read out. Yesterday I was reading that human life may also be, life age would also be expanded, linking with different scientific tool. We may live for a long time because of linkage with these devices. That has also been read out. So natural rule or creativity, all rules are also in question. Now, what should I say is, if the lawyer relies on AI to find correct answer or appropriate solution, but if it is wrong, resulting in miscarriage of justice to client with potential imprisonment, like there may be harassment from court side to the lawyer. In Nepal also such instances have occurred for several times, and Bar Association is to play role of trade union. If AI is innocently relied, there is miscarriage of justice, there may be contempt case as well. And general guideline to use generative AI by IBE, Law Asia would be appropriate to address these issues. Currently there is guidelines on the use of generative AI in mediation only. In other dimensions should also, we must expect Law Asia's guideline. Then after, on the foundation of Law Asia guideline, we are expecting IBE. Actually it was supposed to come in early, lately it has come. That is, thank you. Thank you very much for listening.
Thank you, Dr. Mishra, for your brilliant presentation, and you have already touched upon all the core issues that is affecting AI in this profession. You rightly said that most of the lawyers are not tech friendly. This applies to, I think, our generation and the previous generation. The new lawyers are all tech friendly, right? From the day one, they come with the iPad and they join the profession, and the very next day, if you ask them to prepare some note, they will draft the petition itself. So you're surprised, how did this happen? So, all through AI. ChatGPT is helping them, notwithstanding the fact that sometimes they cite a judgment which was never pronounced. So, and you said that justice is godly, justice is divine, right? If you pass the judgment on the basis of AI, it will go on the precedents of the judgments. So that is not the case, because each case is unique and judge applies its own mind on the basis of the facts and circumstances of the case, notwithstanding the precedents. Sometimes there's a deviation also. So law is not static, it is dynamic, always developing. So therefore, whatever has happened in the past is also subject to change with the advancement of time, age, and circumstances, situation demands. You said about the English translation. Translation is misplaced. Yes, you're right. Many times, a very interesting incident happened. Supreme Court is also translating all the judgments into various languages. As you know, India is diverse, and 26 languages are recognized by the Constitution. There are many more languages.
So Supreme Court is translating the judgments. There's a, under Article 136 of the Constitution, that's a special leave to petition. So you file a petition, you get a leave from the court, then it is converted into an appeal. So the translation for leave granted was, I am saying it in Hindi, Chutti Manzoor. That is means you have been granted holiday. That is the leave. So you said about that creativity is lost. Yes, it is all tool based, so your mind, stop working. But I have come across a recent survey conducted by Thomson Reuters, which says among the legal professionals currently using AI tools, 77% use it for document review, and 74% use it for legal research, and 74% are using to summarize the documents, and 59% are using it to draft briefs and memos. So that is enormous. So everybody is depending on AI. What do we do then? With this observation, I will invite Mr. Isaac Chan, Barrister, Hong Kong Bar Association. Mr. Isaac's practice focuses on commercial and financial disputes, financial regulatory proceedings, banking disputes, trust and property disputes. He is often instructed to file cases involving complex elements which require multidisciplinary analysis. In addition to his advocacy works in the courts, he regularly acts both for and against regulators in professional disciplinary and regulatory proceedings. Isaac also advises regularly on matters related to inquiries by the listing division or proceeding before the listing committee and listing review committee of Hong Kong Stock Exchange. He is a white-collar criminal defense lawyer, and he has been involved in the trial of former Chief Secretary of Hong Kong for corruption and former chairman of the Hong Kong General Chambers of Commerce for conspiracy to defraud. Mr. Chan, please.
Thank you.
Here's a PowerPoint presentation. Can you have that?
No.
The PowerPoint.
Perhaps in the meantime, I just crack on because first of all, Mr. Kumar, Mr. Devan, Ms. Srivastava, dear colleagues from Asia and the Pacific, it's such a huge honor, and I'm very grateful for being given this opportunity to stand up here and share my thoughts and views about legal education in the AI era. I have prepared a PowerPoint presentation, and I was preparing the opening line by saying that I resisted the temptation to generate the PowerPoint presentation by AI tool. And so I mostly did it by myself, with one exception. Before we explore what should the legal education policy and training these days in the AI era, I would like to invite everyone to have a jog down the memory lane and to look back in the past and think what was the last technological advancements that actually had a huge impact on the legal profession, the legal practice, and the society in general. Of course, I asked Copilot, that's the AI tool that I use kind of daily now, as to what was the past technologies that had such a huge impact on us. And Copilot gave me a very predictable answer, that it started from the advancement of internet, which seems to be kind of an obvious or a go-to answer as to where the technology actually started to have a crossover with the legal practice. But having read the answer from Copilot, I actually disagree. I would argue that it actually went one step back. That was the fax machine. It was the first ever tools or technology that actually allow instant written communication, and more importantly, instant transmission of legal documents. And it was that means of communication that exploded the volume of international trades and financial transactions. Now, looking at my face, I don't claim to start the practice in that era and witness the transformation. I'm sure there are more qualified people in this room to tell what fax machine actually made a difference back in the days. But coming from Hong Kong, which is an international financial hub, we did witness how the instant means of communication and transmission of documents feature in every aspect of international finance and international trade. And then, of course, the next thing would be internet. And without internet, we all wouldn't be coming here with such an ease that I bet that some of the colleagues here are actually working remotely and whilst participating in this conference. Without internet, we won't be able to do that. And a lot more technologies actually flowed from the internet. But instead of just focusing on the face value of the text or what are the tools that have been available throughout time, let's look one level deeper as to what actually changed with all the technologies that came about, starting from, according to my theory, the fax machine. So first of all, I would argue that it was, first of all, the compression of time span that we actually have as lawyers in handling everything. First of all, everything was expected to be instant ever since the fax machine. A document would be transmitted from the east to the west in a second. And with that instant means of communication, it's not just the lawyers themselves expect things to happen faster. The major pressure actually comes from the clients and also the courts. The second transformation, I would argue, is the digitization of information. And coupled with the availability of the internet, all the information after being digitized become ever more publicly accessible. And third, it's the globalization of operations. Just as I mentioned, I believe some of the colleagues are already remote controlling your office as I speak. Law firms and legal practices greatly benefited from the instant means of international communication and therefore was able to establish the international presence in many more jurisdictions under one single business umbrella, which was very hard to establish without such an instant means of communication. Now coming to the more recent trend of generative AI, the transformation, I argue, would happen about automation. In fact, some of the people actually argue that generative AI is not exactly the kind of AI that we expect in our mind. It's just an advanced form of automation, just that the AI tools are now being more able to execute a more complicated sets of instructions. But yet the underlying logic and the underlying tech is still very logical and is still very mechanical in some ways, just that they can operate on multi-layers and give us the impression that they are now more human-like when they are still just a very complicated form of automation. And finally, the transformation that I probably can detect from the appearance of AI is actually the prediction, approximation, and simulation that now the tech might be able to perform that wasn't be able in the past. However, the predictive tools seems to be a sort of a myth to many of the people because as of now, according to my understanding from the information that I can gather from the internet, it's the US law firms that are having the most powerful predictive AI tools that they actually deploy in their daily practice. And I saw a survey that actually now 47% of the US law firms would use predictive AI tools to actually try to simulate if a particular case with the particular set of evidence goes to court, what would be the outcome? Of course, we wouldn't know the actual percentage of accuracy because it's some sort of a trade secret for them. And I will come back to this topic because AI tools development probably would feature in our daily lives or in our daily competition across jurisdiction.
No, this is on now.
Sorry.
The PPT.
Oh, thank you.
Yes.
Now, as you can see from the design of the first page, it really is manually generated. This is the co-pilot product of the timeline as to what technologies have actually transformed legal practices. Now, allow me to be looking to the future a little bit before I turn to the legal education policy. As we can already sense or understand from the publicly available information, the next tech that might occupy lawyers more and more probably would be the blockchain technology, the smart contract which would allow transactions to be self-executing. For colleagues here who are more in charge with transactional works, of course, I'm not an expert. I'm a barrister focusing on dispute and litigation. But I understand that a lot of transactional works actually comes down to the actual steps of execution that requires lawyers to help perform. But with the exponential popularity of smart contracts, one day perhaps a lot of the executory steps in a transaction can be done away with. And of course, the blockchain technology, it's closely tied to cryptocurrency. And in the future, payments will be more and more prevalent in the form of a cryptocurrency. And in Hong Kong, we just passed the new law about stablecoin. And as of now, 3 stablecoin issuers are being sandboxed. That is, they are being vetted by the Hong Kong Monetary Authority as to their tech and as to their ability to operate a stablecoin issuing business. And therefore, we very soon can expect some sort of official payments can be made by stablecoin. The second trend that may transform the legal practice even further is the availability of the artificial general intelligence. What does that mean? Now, the ChatGPT DeepSeek Copilot that we are looking at, it's the generative AI with the use of the large language model. Artificial general intelligence is one step closer, if not one step beyond the simulation of human intelligence. I was listening to the podcast of the founder of DeepMind, that is a Nobel laureate in biology who also happens to be a computer scientist from Singapore. He was predicting that in 5 years' time, Google actually targets to do this experiment. That is to develop artificial general intelligence by feeding the AI tool with all the physics, theoretical physics materials. That was all the way up to the moment when Einstein published the theory of relativity. They would stop there. They won't feed the AI with the theory of relativity, and they would ask the AI and try to test it whether the AI with all the available materials to Einstein can actually also come up with the theory of relativity, like Einstein did with what he knew back in the days. So, and of course, being the developer, they have to be very optimistic, and they predict that that can be reachable in 5 to 10 years' time. So, tone down the optimism, we give it 15 years. Probably in 15 years' time, when it comes to the 50th POLA, we will be talking about artificial general intelligence at that moment. And of course, we are very nearly at the breakthrough stage of the quantum computing. It's one of the tech that would entirely transform internet as we know it. Internet security would be completely meaningless when quantum computing becomes available. And when quantum computing is being combined with artificial general intelligence, we are looking at a whole new world, for better or for worse. Now, how did the past technology advances have impacted upon legal education and training? And speaking from my personal experience of working together with the universities even after I started practice, regrettably, I would argue that it was a lost opportunities because in the past 25 years after the popularization of internet till now, the mode of education in universities and also the professional bodies as to how we continually trained our members, the past technologies didn't seem to have a very serious impact on how law was actually taught and how lawyers are continuously trained in the profession. Of course, we would make do. Oh, there is a new tech, we try to learn it ourselves. We learn on the job. But back in the universities, you can still see that it's very much the students being told to read a lot of materials, The student would have a debate with the professors as to how they understand the legal principles are, and they try to apply the principles in a mooting environment. And the mooting format did not change a bit when I was a law student compared to today, I think. Having said as a moot judge, and I was also a keen mooter back in the days of the law school, in the past quarter of a century, nothing seemed to have changed much. So, and also in the three core elements of the legal education and training, they are knowledge, they are the know-how, and they are the ethics. The emphasis has always been on knowledge across the world, as I can observe. Know-how, again, is very make-do kind of attitude. If there's a new thing, you just improvise. And back in the days when I was in the law school, I think it was the very beginning stage when Lexis and Westlaw become very popular and available to every university student. Perhaps the time we spent on learning that tool was about 20 hours, together with the assignments that we were told to do, and that was it. So that was probably still the same, even today in the law school, as to how the law school would actually try to equip the law students with all the necessary knowledge and know-how in the legal tech. And ethics is even more interestingly to be an even smaller element in all legal education across the globe. You can survey the curriculum from Oxford, Cambridge to University of Hong Kong. Ethics probably would be parked to the very end of the curriculum, and again, with very minor emphasis being placed on it. So we probably, in the past quarter of a century, have missed certain opportunities to better equip lawyers for future technologies. Now, before I dive into my suggestion as to, or what Hong Kong is doing about the legal education policy in respect of the AI tools and transformation of technology, can I venture my thoughts as to how the AI as we know it now, or before the AI reaches the stage of artificial general intelligence, would actually impact on the legal practice? Something has already happening. First of all, the generative or the large language model AI, again, further compression of time span, I would expect. In a normal course of litigation, of course, there will be deadlines imposed by the courts. And we, time and again, would need to go back to a judge and say, oh, can I have some time extension? With the availability of the AI tools, we can only expect more ruthless monitoring of progress of a case by the judge and say, no, you only have 28 days to deal with an affirmation that will require you to trace back years of electronic data. Two, information expansion. That's something that we can observe from the internet age. Yesterday, or the day before, I was having a casual chat with my chairman, Jose, and we were both complaining about the need to deal with thousands of pages of text messages in any given commercial disputes, which was unimaginable 15, 20 years ago, before the prevalence of the text messaging tools like WhatsApp or WeChat. But now that we can observe from the past trend that the more communication technology that is available, the more information that will become relevant in any given disputes. And the more we, the lawyers, at least the dispute lawyers, would need to trawl through, analyze, and try to pick the relevant bits, that really would make a difference in the litigation. But with the generative AI, with the ease of people coming up with pages and pages of writing, that is something that we can already expect. That is the explosion of amount of information we as the litigator would need to handle in the future. And I gather that would also be true for lawyers who are dealing with transactions. The negotiations, the contractual documents, they are more and more drafted by the parties with the AI tools, and we can expect them to become longer and more complicated. And therefore, it's one challenge that we, the legal practitioners, would definitely face going forward. Three, of course, with more information, the AI would also provide partly the solution. That is, already more and more lawyers, as the panel chair lady has shared with us, are using AI to analyze documents and try to summarize them. So they generate it, they better sort it out as well for the lawyers. But finally, there will be, and there is already a trend, at least in Hong Kong, about people doing self-help legal services to themselves through the AI tools. 2 months ago, I was actually dealing with a case with a litigant in person on one side. And I received pages after pages of submissions that is apparently drafted by AI tool by this litigant in person. Of course, they are completely irrelevant, and they only sounded nice, and they addressed the grievance of that particular party without actually very relevant legal analysis, because the tech as of now is they are as good as what you feed them. So they are as good as your prompt. If you ask the wrong question, they give you the wrong answer. If you refine the question wrongly, they would even perfect the error, so to speak, more seriously. But it's already a trend. I also hear another story that after DeepSeek became so internationally popular and available, some companies in Beijing actually sacked the entire in-house legal department. And they would draft all the legal documents, at least the first draft, themselves by the executives, and they would directly go to the external lawyers and ask them to vet and endorse. So that is a trend that has already happened. A lot of people, with the aid of the AI tools, will become ever more confident that they can at least do the first draft themselves. This is, again, one phenomenon that we all sitting here would need to deal with. Now, coming to the final trend of the prediction, of course, we are still 15 years ahead of it. But when artificial general intelligence eventually becomes available, there will be a temptation to hand over the decision-making power to the AI tool. When LLM is already available, people are already sacking their in-house counsel. When artificial general intelligence is available, would the society eventually regard the lawyers irrelevant because the AI tools can make up with a better decision? It's something that we need to address in the near future. Now, lastly, may I share what is being discussed in Hong Kong as to how we can devise a better policy in legal education and training for lawyers. First of all, it's being done as a joint effort between the judiciary, the Department of Justice, the universities, and the legal profession. We have a standing committee established under the law to address all questions about legal education, and the recent focus is on the AI training. We have a consensus that the first thing to be done about legal education and training is actually to have a better tool, because the so-called arm race has already started. As I just mentioned, the US law firms are having much more powerful AI tools than the rest of the world. The tools like Harvey, the tools like Silo, they can already do some very sophisticated and advanced drafting and analysis, up to the level of at least a middle level of associate. So jurisdictions that do not have the benefit or privilege or access to such powerful AI tools would eventually face very stiff competition, because in areas like international arbitration, when the specific need of lawyers being based in a particular jurisdiction is actually ever more on decline, you might come up with an international arbitration with a US law firm on the other side, arming with very powerful AI tools, when you don't have the equally powerful tools up your sleeves. What do we do? So Hong Kong identified this problem, and we are in the moment of discussing as to how we can get the resources to develop a local legal AI tool. Hong Kong's challenge lies in the fact that we apply case laws in many jurisdictions. So far we have the Lexis AI tool, the Westlaw AI tool, who can allow you to actually summarize the law in one particular jurisdiction only. But they cannot actually do a cross-jurisdictional cross-check as to how the case law has been developed in different common law jurisdictions. So this is one particular challenge that we have identified and we are trying to solve. But again, everything starts with where comes the money? And this is something to be discussed very fiercely internally. And we have identified a few matters that should be included into the university curriculum and the future continuous professional training program. First is the promotion of AI literacy. I don't claim to be very literate in AI. I'm very rudimentary in my skills of using Copilot. So it's something to be addressed and have to be addressed urgently. What exactly does AI literacy involve? we have identified three things. That is the prompt engineering. Second, knowledge encoding. We can't replace the decoder in any event, and the coders are being replaced by AI anyway. But some knowledge encoding and the structure of how those AI tools are actually derived would be very helpful for legal practitioners to understand prompt engineering. And third, fraud detection. All the deep fakes, and we have to identify sources of fraud and features of fraud which are generated by AI, and we need that ability going forward. But the consensus by the judiciary, by the Department of Justice, universities, and legal profession is that the most important element of legal education and training going forward is professional ethics. Personally speaking, it pains me when I listen to the junior lawyers describing the legal practice as a service industry, when we are not. We are a profession. And the difference lies in the professional ethics. There is nothing wrong for anyone to run a service industry or service business. But really, there is something that sets the legal profession apart from being a mere service provider. That is the professional ethics. The ethics that we owe to the clients and the professional duties that we owe to the court, which are both users of our advocacy and our advice. And secondly, we need to reinforce the students and also legal practitioners' understanding about the fiduciary nature of the relationship. That is, we owe a duty of loyalty to our client. We owe a duty of loyalty also to the court, and we need to avoid all conflicts of interest. We always need to put the client's interest ahead of us. This is true on the individual level, and this is also true on the collective level. That is the entire profession. In order to stay relevant to the society, we need to tell the society that we are here to defend something on their behalf. We are not just here as a counterparty in every transaction and try to make the maximum amount of profit out of it. And therefore, it's actually very inspiring and touching to listen to the past panels talking about how the bar in different jurisdictions would actually stand up and protect the human rights, whether for the general public or for the legal practitioners. These professional ethics and ethical values are something we have identified that needs to be emphasized and re-emphasized even earlier in the legal education program. And of course, finally, the confidentiality and also diligence are very well talked about. Whatever you upload to the AI tool, be careful who owns the data anymore. We might be inadvertently giving away the ownership of the data. And again, we need to do all these diligence about fact-checking and not using all these fabricated materials and submit it to the user of our advice or legal representation. So I know the time that I have already taken, and I conclude my remarks here. Thank you.
Thank you, Mr. Chan, for your presentation, and sorry for the little goof up. That is AI. So you rightly said that we have traveled a long way. Perhaps your generation is not aware that before fax, a telex also existed, the telegram and telex. So instant messaging was transmitted through telex. But of course, only urgent and important messages used to be transmitted. So telex to fax to internet and now AI. We have traveled long. So all these were used for the communication technology, basically the telex and fax. We have seen that what you have flagged, that many times reasoning is lost in the ratio. When you give a presentation, or you see the document summarized by the AI, the reasoning is lost, and that we have seen in our judgments also. Now the earlier judgments by the court used to be, if you see the 60s or 50s judgment, they were very short and crisp to the point, running into 7 to 8 pages or 10 pages maximum. Now we have the judgments running into 700 pages. And we still can't understand the reasoning, the ratio, what is the ratio of the judgment? Because all judgments are with the click of a mouse are lined up and they are reproduced. Whether they make sense, they are relevant to the topic, to the issue or not, but they are there because the keyword is picked up. So that is the flip side. You also mentioned about the duty to the client and duty to the court. That is very important in this era because as a professional, you just can't rely on the AI for these things. I have one more important prediction to share. It says, the prediction is by future of professionals. They say that AI could free up approximately 240 hours per year per legal professional. So if workflow becomes more streamlined, 43% of the legal professional anticipate a decline in hourly billing models. So you be prepared for that. Your presentation is ready or not? I'm just taking time. Is it?
We still have one last speaker.
Yes, presentation. The PowerPoint for the last speaker. May I now invite Mr. Chow Seng Chon. He is a lawyer and a government-appointed notary in Macau. He is a member of Council of Macau Lawyers Association and chair of its Legal and Technology Affairs Committee. The major duties are to research Macau's SaaS basic legislation and analyze how technology progress affects the legal profession and its innovative applications. Your PPT is ready.
Thank you, moderator. Good morning, everyone. I'm Lawrence Chow from the Macau Lawyers Association. The title today is The Balance of a Double-Edged Sword, Integrating AI into Macau's Legal Practice. I want to explore the transformative role of AI in Macau's legal landscape. It highlights how AI can enhance efficiency and accuracy while maintaining the core values of the legal profession. We'll dip into the practical applications, educational imperatives, and essential safeguards to ensure a balanced integration. Okay, now let's imagine, let's say there's in a movie, there's a complicated court case where thousands of documents are being found. It would take weeks for a group of fresh lawyers working non-stop to go over them all. But an AI tool can finish it in 2 days and get it right over 95% of the time, and pick out the most important data almost right away. This is not a science fiction story. We are seeing this now in some courts and law firms in China and around the world. It's also going to Macau SAR. The legal system of Macau SAR is unique. As I said yesterday, a blend of Portuguese civil law tradition within a Chinese SAR framework. This creates a fascinating landscape for AI, a lead for tools that can navigate Portuguese language and Chinese language documents and understand our specific context. Today, I think the question is not whether AI will change the way lawyers work in Macau, but how? How can we use this huge power without losing our sense of what we do as professionals? In the next few minutes, we'll talk about how AI affects legal practice in Macau, how our legal education needs to change, and the important safety measures we need to put in place to make sure AI improves, not replace legal expertise. Let's start with the practice of law itself. AI isn't just a fancy searching engine. It's a basic way to make things stronger. First, legal research and discovery. We go beyond simple face searching to understand what words mean. An AI tool can look at Macau's law, decades of Portuguese language, and most recent Chinese language court decisions and cases from other similar civil law jurisdictions to find hidden trends and past cases faster than a person do. At the same time, litigation strategy and prediction, AI can look at data from Macau courts to figure out how likely it is to win in front of a certain judge, how long a case will take, and even which strategies or pawn will work the best. This isn't about replacing a lawyer's gut feelings. It's about giving it more power by giving it data-driven trust. This may change how we give clients advice and decide on settlements. Followed by contract drafting and due diligence. AI can quickly make first drafts of standard contracts for Macau's active real estate and gaming industries. It can also instantly mark any non-standard or risk causes and do due diligence by looking over thousands of paperwork for risk and obligations. It makes the process smoother. The key message here is AI is a liberator. As our moderator said, it frees lawyers from routine, time-consuming tasks and that they have to do over and over again. This let us focus on the important work that makes our job unique, namely developing deep strategies, advising clients, and perfecting the art of persuasion. In what way can the lawyers of Macau embrace the AI generation? We need a fresh type of lawyer for employing this new tool. This is a substantial skills gap driven by this. Our traditional legal education is excellent at teaching theories and case analysis, but it's not designed to make professionals who are proficient in technology. The law school in Macau need to have transformation. We have to incorporate the following elements into our curriculums, which is the legal tech modules. Students must be taught how to use research platforms driven by AI, e-discovery tools, and contract analytics software. This should not be an elective, but a compulsory element. Second, the data literacy. People who want to become lawyers in the future may need to know how AI models work, what their limitations are, and how to understand what they generate. They need to learn how to properly question the AI. Number three, enhance core skills. It's charming, yet we must emphasize more than ever on what makes us human. Critical thinking to validate AI suggestions, ethics to navigate the morality of predictive justice, and advocacy, the human skill of persuasion that AI cannot replicate it. It is an continuous education. Bodies like the universities and our association must lead the change in lifetime learning, offering continuous training for practicing lawyers on these new tools and the ethical issues they present. Now I'm going to talk about the most crucial part, the safeguards. How can we make sure that this powerful tool works for the law and not against it? Yesterday, I chat with Mr. Nixon. At the same time, I asked him not to ask too complicated question to me today. And I think I have his work. Mr. Nixon pointed out an important issue of using AI, which is the risk of the outcome. I hope this part, which I'm going to talk about, may give us some hints. The human in the loop principle is the first and most important safety measure. This must not be non-negotiable. A licensed lawyer should always look over, check, and be responsible for work made by AI. This is not the AI that signed the documents. It is the lawyer. The lawyer are the ones who should be held accountable for how the legal service turned out. Also, we need to fight bias and demand transparency. AI models are taught on data, and our data has bias from the past. We need to expect explainable AI and check these tools for bias on a regular basis to ensure fairness and justice. This is especially important in Macau, where people from different cultures live together. Third, we need rules and guidelines for ethics. Macau's legal institution must develop clear rules on client confidentiality, data security, and unauthorized practice of law in the area of using AI. We need to make sure that AI does not make it harder for people to get justice by making the gap between firms with and without resource bigger. Preserving the fundamentals is our best defense. The rule is not just a digit. It takes moral thinking, understanding, and creativity. Our goal must be to keep working on developing these skills that cannot be replaced. Now come to the conclusion. To sum up, AI will change practice, which will force us to change how we teach, and it will also need strong safeguards. The ambition for Macau's legal community is for everyone to be truly bilingual. It means they understand both the language of the law and the logic of the technology. So let's be open to new ideas with care. Let's teach our profession properly, and let's work hard to build our barriers of safety. The last but not the least, our association is open to new technology, which will enhance the quality of practicing. And we have to make sure that the future of lawyers in Macau is not one of replacement, but one of incomparable advancement, where technology and human knowledge work together to uphold the justice and serve our client better than ever. Thank you very much.
So the conclusion from the panel discussion is that the traditional role of lawyers cannot be replaced by AI. That is there. Because the human mind, it's not that the legal thinking does not work in a timeline. You have some issues, your mind is working 24 hours. And sometimes it is very odd hours that you get a point, a good point for your case. So it's not fixed timeline for a legal reasoning to work on. So with this, I open the floor open the discussion to the floor. Any questions, any observations? I think everybody in this hall is impacted either way with this AI. Yes, please. My friend from Australia, the president of Law Council of Australia.
Thank you. That's been a very interesting presentation and very insightful. One thing that has been troubling me, and only because one of our Chief Justices has actually asked the Law Council how we were going to make sure that our first and second year lawyers would still have jobs at the end of the introduction of Gen AI through all of the firms is this. One of the most important ways that you learn as a young lawyer is to make mistakes and have them corrected, and have them corrected by a person in front of you. I am wondering what your insights might be about young lawyers using AI to prepare first drafts and then not having gone through the process of actually thinking about how to create the first draft themselves and make the mistakes to get corrected. So they get a product that is probably far better than they could do themselves, but they don't pick up the flaws in the creative process of that. And I'm just wondering how we accommodate that in our teaching of young lawyers. It was a bit like the point that I raised yesterday. How do we get our first and second year lawyers to become useful third and fourth year lawyers with the knowledge that our third and fourth year lawyers have at the moment about how to do things, if they're being taught in a different way?
Would you like to answer this?
Thank you for your question. The young lawyers, the fresh lawyers, they provide the first draft by using AI. I'm not calling for getting rid of basic law principles. They should, as a lawyer, they should have the very strong legal theories and principles. The rule still stands there. We need to integrate the technology into classes that are already being taught in. For example, in the contract class, students should use AI to write and think about a phrase. It would be possible to run an e-discovery exercise in civil procedure law and commercial law. It's important to teach along with the tools, not just the tool themselves. Not just the material has changed, the way it's done has too. Thank you.
Can I also offer two short answers? The first one, again, looking back, the use, for example, Lexis and Westlaw, sometimes I would ask the junior and the pupils as to what are the keywords you have searched or you have keyed into the tool. I think in the AI era, probably we have to do what we have to do about correcting mistakes for the juniors is not just to look at the end products itself. Perhaps we as the trainers would need to ask them to reveal to us what were the prompts, what questions you have asked, what instructions you have given, because that really is the thought process. Perhaps, again, that this is something that we have missed in the past. We just tell the people how to use Lexis and Westlaw, and we hardly ask them how did they actually use it. Going forward, for the AI training, perhaps that would be the focus. Second, is actually the encouragement of teamwork. I think, again, this is something missing in the legal education in the past. We quite encourage people become ever more individualistic. And we quite, fancy, we all of us becoming Harvey Specter in Suits, that I am the closer and it's always me and I. But perhaps in the AI era, it's even more important to encourage the young lawyers to work as a team and to collaborate as a team. And that is where the human factor can be amplified and can be emphasized.
The matter is clear. Actually, nature has installed AI instrument in our mind. By birth, we are inquiring a lot of things. Also, we start by bicycle, then motorcycle, car, aeroplane. In such a line, development process is going on. I think there should not be installation of modern AI instrument in our mind replacing the old one. So it is just supplementary and addition that will beautify our presentation. Thank you.
I think each one of is impacted.
We have 2 questions from here.
Okay. So may I request Pooja to ask your question? Yes.
I do not have a question per se to the
Just
panelists,
an observation.
but I would like to highlight certain points with regard to India. Recently, I have come across that AI has been, education with regard to AI has been introduced in school. I have come across this only in one school. But my suggestion would be AI should be introduced with regard to high school students and higher secondary school students, so that when they enter the legal education system, they are well aware about the basic concepts of AI. That is the first step. Secondly, when we go to the legal education step, we come across the national law universities in India. We have paperless national law universities as well in India. But if we talk about traditional law colleges, they are not at all equipped with AI. They don't have facility to various softwares like Westlaw, Manupatra, SEC Online, etc. So these things need to be brought in the traditional law colleges as well. Now, when we talk about litigation, the Honorable Supreme Court of India has introduced the Electronic Supreme Court Reports, ESCR. It used to be in a hardbound form earlier. Now we have the ESCR, which provides us with all the Supreme Court judgments as well as High Court judgments. So just like
Free of cost.
Free of cost. Just like the SEC Online is now developing an AI developed SEC, in the same way, if the Supreme Court would develop ESCR into an AI-assisted ESCR, it would be a beneficial move, and the gap between the top law firms and the small law firms can be bridged. Thank you.
But you start the AI at the school level, then where the reasoning come from?
The reasoning will come later,
Yes.
but the basic
So
concepts
those is
of how to search,
before,
what to search.
Before 12, CBCs.
How to search and what to search should be known at least.
Any observation?
I have to.
After this one more. You were asking the gentleman there? Pooja, please give the mic. You be the last.
Thank you so much. Our respected President, Chair, made a very important observation. Empathy and constitutional morality cannot be replaced by AI. It is with that spirit, I am Ananta Kumar Giri, a sociologist and philosophical interest. My query is that so far in this session we have talked about ethics, but also we need to talk about aesthetics. There is a very important genealogy of linking law and literature, and it is in that context in what way AI and legal education must include not only ethical issues but aesthetic issues. And my second quick query is that the legal profession does not work in isolation of society. Profession also has a cult of closed professionalism, and that is not helpful for society. So how does profession creates a critique of closed professionalism so that it is also responsive to society, and in that way how technology can help us in opening up a sense of closed professionalism to a much more responsive professionality.
The aim of, yes, I agree with the aim of law is prosperity, happiness, peace, harmonized relationship, distribution of materials to all the people. Law is struggling to establish its place in the society. It is in a struggling stage up to the present time. One of incidents I remember, law has secured victory only in one occasion. That is, it has defeated and eliminated sati system. Apart from this, I hardly find out any example in which law is winner. So, law must be strengthened. In order to strengthen law, different devices of different disciplines of the society must support to legal provision, in which AI is one of tools. Actually, humanity is our supreme religion, practical religion, our goal, our objective, that is supported, propounded by Mahatma Gandhi as well. As a consequence, AI should be introduced in school education. How to apply, what are merits, demerits, what is humanity, that should be included in curriculum as well. And basic perspectives of the society must have been preserved, bad customs must have been eliminated. I do agree with both presenters. Okay.
Thank you very much. I think that is almost the best to finish. One short comment of my side. Again, like I said yesterday, we talk about what we need to introduce in universities, coding and all this. Don't we need to also accept the limits of ourselves? I mean, when the telephone was introduced or the first emails, I didn't learn how this technology was developed and how it was coming about. I used it, and I think we all used it. So the fear that AI will take over, I think it's a bit exaggerated. I agree with you that it's a tool we should embrace. And also this, where do they learn, the young students or kids in school? Well, they learn because they use it. Like we learned how to use the email or the telephone or the first BlackBerry, and we never questioned what is behind this. I think where we are all fearful, why we kind of try to find an answer, is that we don't really foresee how deep this will replace us. I think that is really the issue. Before we had the feeling, it will not replace us. Yes, email replaced the letters and the papers partially, but I don't think we should be so fearful, and we should just accept that there are specialists who will do it. We have to give a frame like we do with legal concepts, always giving a framework. Laws will never be detailed, never be focused only on one case, but gives a framework. And if we have then a problem, we will call the experts at expert witnesses to tell us what was the coding and so forth. So I would recommend that we don't overdo it with the educational system. I think it's the contrary. We need to go back to the principles which are taught, ethics and all what you from Mr. Chen, what you outlined. And the tools was the first draft. When you enter a law firm and you don't know anything, because honestly, once we are finished with law school or bar exams, we don't know anything. What did happen in our age? We were supposed to set up a company. So we went to a senior colleague or other colleague and said, do we have a draft of the papers to set up a company? So basically, what we do now by giving prompts or asking ChatGPT or maybe the internal computer programs of law firms is the same before. because we were also looking for drafts. If partners in big law firms need something, they write around an email, hey, does anybody have a whatever formulation for this or that? It's nothing else than if I ask a computer program which is specialized or general ChatGPT. So we should not confuse our fear in our generation to be replaced in the future with the question, how do we educate? My sons, they educate themselves. Yes, they use ChatGPT. They probably even kind of try to trick the teachers because they generate and they put it in another program that it's more human. They put it 3-4 times until the new program says, oh, this is now like a human, and the teacher cannot detect it. That is creativity. And they still have to set up the mind, what do I want to achieve? And this is the beauty. That's why we are lawyers, because every case is new. Yes. There is not a possibility to overcome with one prompt every other case. No. It's always only the basis, and then we lawyers kick in. So I don't foresee that there's such a big change.
True, I agree. Any comment from you? No. There's a question from, yes. Go ahead.
I think first I will give my observations. Thank you, the chair. I think just now you were talking about introducing the AI as a part of the curriculum in the school. So my observation, this is not a question, my observation is that AI is cannot be widely used in the least developing countries because of various reasons. There may be lack of reliable internet connections, computing powers, then insufficient funds, and as well as they may not have there may be a shortage of trained personals. And well, in the context of Bhutan, well, I have to share my, I think, views on that, observations. The judiciary, the use of AI tool I'm talking about in the legal system in Bhutan, till now we haven't even heard of it being used there because the size of the population is less than 1 million, and the judiciary in Bhutan is very efficient, very transparent, and we are responsive to the needs of the people. And there's also no language barrier till now, I think, that the judiciary has been facing, because the language in the court is both in English as well as in our language. And there are translations also available in our courts. So that's just I wanted to just share with you. But in the case of like India, where you have millions of backlog of cases, it may be very useful because it can be useful in speeding up the processes for the case management, and of course improve the accessibility for leveraging the tool of the AI, especially for the case management. But I want to again share with you all that Bhutan is the 5th largest investor in cryptocurrency. So when you talked about this in your presentation,
yes,
I think I heard about the use of AI tool in cryptocurrency. So in that, I think respect, I'm sure that I know nothing about it, but probably Bhutan must be using this. It would be very useful to use AI tool in that. So
yes,
till now, I think we are not closing our doors, but thank you so much.
Now, Anandita is the last question, last observation.
There are more questions there, so I would not like to take time. We would rather take their questions.
Because we already...
Thank you so much.
Yes, you're intruding on lunchtime.
I'll directly go to my question. Mr. Chan has been talking about the litigants coming with the prior research and coming with their own AI-generated documents that they come to you and ask you to submit their documents in the absence of adequate time. And my question is related to that. If a adamant client come to you with a document that is being generated by the AI, and then in your opinion you feel that that document, that particular document that is brought in by your client is not going to help that particular client, and then you will have your own observations and legal waiting over that, but then you don't have time, and then you also don't agree to your client that you're going to go with that particular document. So in that kind of like situation, whereby the outcome of the case is, no matter how hard you work or how like sincere you commit yourself to the work, the outcome of the case is not guaranteed. And in case at the end, if you get a different result,
be brief, please. Can you be brief? Yes.
Yeah. If you get a different result and you have not listened to your client and you went by yourself on your own to giving your the responses to the case, then the client may allege you of some of your professional duties that you have not listened to your client, where you have the utmost duty towards the client. So in that situation, do you have any kind of regulation, the professional ethics and conduct of the lawyer, where you can insert some kind of changes and provisions to protect that? Thank you.
Thank you. I think it's just the same as any other urgent situation. Time and again, we receive very urgent instructions, whether with or without a thick pile of AI-generated documents. And again, this is the importance of going back to the ethical code. How do we generally deal with urgent instructions as such? If we are only given so much time and so many materials, normally how do we deal with it? And it all goes back to the code itself and our professional ethics in general. If we just have that much of time, of course, we have to honestly tell the client that, look, I'm not a magician. I'm not even very AI savvy. And in such a given time, I can only give you so much. It's that very basic professional interactions that, in my opinion, will save the day. Because the court will recognize in the future litigation about negligence or whatnot, the court still has not disregard the human factor in us or the human limit in us. And let's hope that it stays that way.
With that, we will conclude this session. Thank you. Sorry, Anindita, you have to stay. So I thank all the panelists for the brilliant presentation, and thank you to the audience. Thanks a lot.
from here?
Yeah, I'm comfortable speaking here.
You're comfortable speaking from here? Whatever you choose.
So I'll just borrow the clicker and then
Okay. इनको click कर दीजिए.
Yeah, well, it's with
इनको
Robin.
PPT.
Yeah, it's
अच्छा,
okay.
let's see. Am I audible? Yes. Good afternoon, everyone. I think we should start because we must stick to the timeline given to us. This session is supposed to start at 2 and we are already running late by 5 minutes. And we do understand there is one more session to go. So it's important that we begin. Although we fully appreciate that some of our friends are yet to settle down inside this hall and some of our friends are still having their lunch. So pardon us for starting the session nevertheless, and we would begin. So this session is something where I think all of us are going to speak from our heart. So many of us, we might have a lot of stories to share, a lot of narratives to give, because this particular session is about the future is inclusive, intersectionality and lawmaking. I think the theme, it has been designed, as somebody rightly says, it's all about design. So as the theme is rightly designed, it already declares and begins with a hope and aspirations that the future is inclusive. So there is no way to look behind and explore whether it should have been inclusive or not. We now at a point where we recognize that we need to work towards making it more inclusive. And when I say inclusive, there are multiple definitions. And when I say we are talking about intersectionality, we all know right now sitting here, you all would appreciate, I might be somebody coming from the east of the country, a woman and a lawyer all at the same time, who is a mother and now chairing a session all at the same time. So you all play multiple roles all at the same time. So we are talking about multidimensional, multiple approaches at the very same time. So it's about living your life to its fullest at this moment. So therefore, here we are going to discuss on the theme of future is inclusive, intersectionality and lawmaking. Why lawmaking becomes important is because many a times there are multiple mutinies that are happening in a given societies. There are multiple stories that are being written. And therefore it is important that we discuss as many as possible, share the experience, learn from each other, and work towards more inclusivity, more accommodation, recognizing that the intersectionality can actually play a very important role in the way we as a society and the legal profession as a profession behaves and grows and changes. So we are here to talk about from becoming to being. So we are here to talk about the existence of many, not in the periphery, but in the mainstream. We are here for that. So to begin the discussion, I would now request, I'll go by the schedule as printed so that we can follow the scheme that is already given here. And please pardon me for the incorrect pronunciation, if any of the names. I beg pardon at the beginning itself. So I now request Ms. Riko Fushigami, if I'm correct, now President, Japan Federation of Bar Association, to share her perspectives on the issue.
Good afternoon, everyone. Thank you for giving me the opportunity to speak to you today. First of all, I would like to express my deepest gratitude to Bar Association of India for your hospitality. I'm the first female President of JFBA. Today, I would like to talk about JFBA's approach to diversity and inclusion. I will now speak Japanese. はじめに日弁連における女性比率についてお話をします。Not sound.
First, let me talk about the percentage of female lawyers in Japan.
女性弁護士は私が弁護士になった40年前とはまだ 4% 程度しかいませんでした。昨年ようやく 20% を超えたところです。
When I became a lawyer over 40 years ago, women lawyers accounted for only about 4% of the total, but last year we finally exceeded 20%.
私が日弁連創立以来、75年目にして初めての女性会長ということをもってしても、日本における弁護士業界は男性優位社会であったということをご理解いただけるものと思います。
Even considering that I'm the first female president in the 75-year history of JFBA, I believe this reflects the fact that the Japanese legal profession has been heavily male-dominated.
しかしながら、昨今、日弁連の副会長や各地の弁護士会の会長に女性が増えてきており、弁護士会における女性リーダーも増えつつあるというところです。
However, in recent years, the number of women has increased in leadership positions, such as vice presidents of the JFBA and presidents of the local bar associations, and the number of female leaders in the legal profession is growing.
特に今年の日弁連の副会長は15名中7名と過去最多になり、日弁連を支えてもらっています。
Notably, this year, 7 out of 15 vice presidents of the JFBA are women, marking the highest number in our history, and they are playing a crucial role in supporting JFBA.
日弁連では多様な価値を受け入れ、尊重し、活用すれば、弁護士業界にもイノベーションが起き、変わっていくと考え、これまで多くの取り組みをしてまいりました。
The JFBA believes that by embracing, respecting, and utilizing diverse values, innovation can occur, and the legal profession can evolve. We have been actively engaged in various initiatives toward this end.
主要な取り組みとしては、ジェンダーバイアスの除去、セクハラ・パワハラの根絶、女性の皆無参加、経済的格差の解消、啓発プログラムの作成、研修の実施などがあります。
Key initiatives include eliminating gender bias, eradicating sexual harassment and power harassment, increasing women's participation in bar association activities, addressing economic disparities, and developing and implementing educational programs.
特に女性の皆無参加については、日弁連の副会長や理事にクォーター制を導入し、リーダーを育成しているところです。
In particular, regarding women's participation in bar associations activities, the JFBA has introduced a quota system for vice presidents and board members to promote the development of female leaders.
2022年6月には、ダイバーシティ&インクルージョンの推進に関するワーキンググループを立ち上げ、日弁連内における D&I 推進を目的とした活動を行っています。
In June 2022, we established the working group on the promotion of diversity and inclusion, which is engaged in activities aimed at advancing diversity and inclusion within the JFBA.
特にジェンダー平等を D&I の一丁目一番地として捉え、 差別的取り扱いやハラスメントの根絶に取り組んでいます。
In particular, we view gender equality is as the cornerstone of diversity and inclusion, and are working to eliminate discriminatory treatment and harassment.
社会に対してこれらの重要性を訴えてきた西弁連としては、内部を見つめ直すことも極めて有用なことと考えています。
As an organization that has long advocated the importance of these issues to society, it is also extremely valuable for the JFBA to reflect on its own practice.
ここで2つほどジェンダー平等に関する活動、立法活動をご紹介します。
Here, I'd like to introduce to you some of the lobbying activities we are focusing on right now.
日本の民法では、婚姻時、夫婦は同一の氏にしなければならないということになっており、実に 95% を超える女性が婚姻時に氏を変えています。
Under the Japanese civil law, the couple must take the same surname upon marriage, and more than 95% of women change their surname upon marriage to her husband's surname.
1996年に法務省内の審議会で選択的夫婦別姓制度の改正が提言されたにもかかわらず、国会がこれを取り上げようとせず、30年近く法律が改正されないままとなっています。
Despite the recommendation by a Ministry of Justice advisory panel in 1996 to amend the law to allow the optional separate surname for married couples, the Diet, which is our Congress, has not taken up the issue, and the law has remained unchanged for nearly 30 years.
日弁連は当時より人格権の問題として選択的夫婦別姓制度を導入すべきであると主張してきましたが、改めて2024年6月の定期総会において、誰もが改正するかどうかを自ら決定して婚姻できるよう、選択的夫婦別姓制度の導入を求める決議を採択しました。
JFBA has consistently argued that the optional system of separate surname for married couples should be introduced as a matter of personal rights.
同時にワーキンググループを立ち上げ、民法改正に向けたさまざまな取り組みを行っています。
At its regular general meeting in June 2024, it adopted a resolution calling for the introduction of the optional system of separate surnames for married couples, stating that everyone should be able to decide for themselves whether to change their surname upon marriage. Consequently, the working group was established to pursue various initiatives toward amending the civil code.
女性会長である私が西弁連の大きな方針に掲げたことから、全国の弁護士会が一丸となってこの問題に取り組むようになったと思っています。
As the first female president of the JFBA, I believe that my inclusion of this issue in the organization's major policy agenda has led to lawyers associations nationwide to uniting to address this issue.
活動の結果、今年6月に国会でようやく審議が始まりましたが、家族の絆が壊れるとか、両親の氏が違う子どもはかわいそうだなどと言って反対する議員も多く、まだまだハードルが高い状況にあります。
As a result of these efforts, the deliberations finally began in the Diet in June this year. However, many lawmakers oppose the amendment, citing concerns such as the breakdown of family bonds or the potential breakup of hardships faced by children with different surnames from their parents, making the path forward still challenging.
男女共同参画の取り組みとグローバル化が進む中、社会が大きく変化していることに目を向けず、旧姓維持を望む者に選択肢を与えるだけの制度の法改正を否定する合理的な理由はありません。
In an era of advancing gender equality and globalization, there is no rational reason to reject legal reforms that merely provide an option for those who wish to retain their maiden names without acknowledging the significant social changes taking place.
経済団体や労働団体とともに制度の導入を求めているものであり、実現に向けて共同していく所存です。
We are working together with economic and labor organizations to advocate for the introduction of this system and remain committed to collaborating toward its realization.
もう一つの立法の取り組みをご紹介しておきます。
Another activities we are conducting in area of lawmaking, I would like to introduce to you.
日本では2023年6月に LGBT 理解増進法が成立しましたが、この法律は差別解消に向けた理念法にとどまっており、この法の趣旨に反する事象が発生していないかを検証していかなければなりません。
In Japan, the Act on Promotion of Public Understanding of LGBTQ was finally enacted in June 2023. However, this law remains a mission statement aimed at eliminating discrimination, and it is necessary to verify first whether any incidents contrary to the spirit of this law are actually occurring or not, and if necessary, we need to make immediately the necessary changes.
日弁連は2019年7月に同性の当事者による婚姻に関する意見書を取りまとめ、2023年2月には内閣総理大臣元秘書官による差別発言に対し、性的少数者に対する差別発言に抗議し、速やかな同性婚法制化を求める会長声明を公表しています。
Additionally, JFBA compiled an opinion paper on marriage by same-sex couples in July 2019, and in February 2023 issued a statement protesting discrimination against sexual minorities and urging the prompt legalization of same-sex marriage in response to discriminatory remarks made by a former secretary to the Prime Minister.
2024年3月には札幌高等裁判所が法律上同性である者の同士の婚姻を認めていない民法および戸籍法の規定が憲法24条および14条1項に違反する旨の判決を言い渡し、これまでに5件の高裁レベルでの違憲判決が出されています。
In March 2024, Sapporo High Court ruled that provisions of the Civil Code and the household registration law that do not recognize marriage between individuals of the same sex violates Article 24 and Article 14, Paragraph 1 of the Constitution.
これらの高裁判決は、原告側が最高裁判所での違憲判決を求めて上告しており、最高裁判所の判断が待たれています。
To date, 5 high court rulings, actually all of the high courts in Japan, have ruled that they have declared such provisions to be unconstitutional. The plaintiffs have appealed these rulings to the Supreme Court since it rejected the claim of monetary compensation for damage, and the decision by the Supreme Court is still pending.
日弁連としても引き続き同性婚の法制化に向けた取り組みを行ってまいります。
JFBA will continue its efforts to promote the legalization of same-sex marriage.
終わりに、今後も日弁連としては引き続き多様性を尊重する社会の実現のために積極的に取り組んでいく所存です。
Going forward, the JFBA will continue to actively work towards the realization of a society that respects diversity.
Thank you for your kind attention. Thank you.
Thank you so much for sharing your perspective. As at the beginning we said, this session is all about listening to each other's hearts and talks, because we are here to share our experiences. And while listening to you, I could relate to so many of the stories. although in India you have the choice of not changing your surname, but it's always, your life story is always so layered. Because we had a case very early, I think about 30 years ago, where the mother did not, was not the natural guardian to be mentioning a name in banking papers. So she had to approach the court, the Supreme Court of India, to get that inserted, to get that clarified rather. And so even the right relating to your succession, property, all of it. So there are just so many layers to you being as an individual and battling it out. The stories are common and these are shared lives in that sense. So far as bar leadership that you mentioned, in India till date, in the Bar Council of India, we do not have any chairperson, a women chairperson. In bar associations that are there all across the country, I think except for few, which are only a handful in number, we do not have female bar presidents. In fact, a matter right now is pending in Supreme Court where one of the judges that you met yesterday, Justice Suryakant, has in fact passed direction that in state of Karnataka, all bar associations will have at least a few positions reserved for women members, female lawyers, so that they can at least aspire to become bar leaders and the space is provided. Infrastructural necessities are given, because otherwise it's many a times it's about money and power, which women are not able to navigate that smoothly. So the journey has just begun so far as bar leadership is concerned. Judiciary also remains not so diverse, and we have got only one women Supreme Court judge. So therefore, that's a similar story, and we are all traveling together. Now may I request Fraser, to President Law Society of New Zealand, to share his views on the topic.
Thank you, and good afternoon. It's customary in New Zealand when giving speeches and addressing the court to commence with a few words in the language, the Maori language of our homeland. So, he aha te mea nui te ao, he tangata, he tangata, he tangata. What is the most important thing? It is people, it is people, it is people. Out of respect to Maori, we have recently changed our rules of court, permitting the wearing of important Maori taonga or treasures when you're in court. So today I wear pounamu rather than a tie. Although I am Pakeha or European, I claim an important connection via my Maori grandchildren. I'm honoured to be here today as part of this panel to discuss such an interesting topic and to give a New Zealand perspective on how we think intersectionality has played a part in law reform, but also how we as the bodies representing the legal profession around the world can play a role. So the next slide. We have a strong history in New Zealand of promoting rights. We were, I'm going to be boastful now, we were the first country in the world to give women the vote in 1893. And on the screen you'll see the first photo is of Kate Shepherd, New Zealand's famous suffragette. The second photo is of Ethel Benjamin, who was admitted as barrister and solicitor in 1897, and she attended the University of Otago, which is my hometown. The final photo is of Dame Georgina Te Huhu, the first Maori woman to gain a law degree, admitted in 1972, and then elected to Parliament in 1996. So I want to particularly focus on the benefits of law reform led and informed by women and those with lived experience. So we're going to talk about members' bills. In New Zealand, members of Parliament can introduce bills to achieve significant legislative reform. They are known to have achieved significant social change in New Zealand, so they are a particular way in which we see intersectionality and lived experience influence law reform. Members' bills are introduced by members who are not ministers. And on these occasions, the House hands over the power to progress policy to the backbenchers and the opposition parties. So some examples on the next slide. There have been so many pieces of law reform to choose from that it's difficult to pick those to talk about, but I'm going to very quickly run through a few. So, Marriage Amendment Bill by Louisa Wall, and this was about LGBTQI rights, and this allows same-sex marriages, and that was from 2013. The next one is Domestic Violence Victims Protection Bill in 2018. This introduced employment protections for victims of family violence, including a right for employees affected by family violence to request a short-term variation of working arrangements, a new entitlement to domestic violence leave, and amendments to the Human Rights Act to make it unlawful to treat an employee adversely on the grounds that they are affected by domestic violence. Then we have the Holidays Bereavement Leave for Miscarriage Amendment Bill. This was in 2021. This provides 3 days bereavement leave for mothers and their partners where a pregnancy has ended due to a miscarriage or stillbirth. And these rights include parents via adoption or surrogacy. We then have the Harmful Digital Communications Amendment Bill, enacted in 2022, and this bill created an offence of posting a digital communication that is an intimate visual recording of a victim where the victim has not consented. Then on to the evidence, I'll just call it the Evidence Amendment Bill, which was passed its final reading recently, and this bill aims to protect victims of family violence while giving evidence in court by allowing them to give evidence in different ways. For example, by a video recording made before the hearing, in the courtroom but unable to see one or more parties or witnesses, or from an appropriate place outside the courtroom, either in New Zealand or elsewhere. Then the final act, Improving Arrangements for Surrogacy Bill, which was originally a members' bill, which has then been accepted by the government. The aim being to streamline the surrogacy process in New Zealand. The Member of Parliament bringing this, he and his partner had a son via surrogacy in 2019, but when their baby was born, they couldn't legally take him home for a while due to the adoption process that is required. So moving on to the next slide, what we can do as champions. So it's critical that we represent and reflect the society that we live in. Traditionally in New Zealand, the profession has been dominated by white, middle-class, older men like me. A more diverse profession is one that better serves our communities and better protects the rights of the most vulnerable. By promoting diversity and rights, we are showing leadership not only within our profession, but within our society generally. I want to briefly touch on 2 important programs in the Law Society. Firstly, Women in the Law, and secondly, our role in championing our Indigenous people, the Maori, and their rights. So, on the subject of the Gender Equality Charter, this was a set of commitments aimed at improving the retention and advancement of women lawyers. For many years, 2/3 of law graduates have been women coming into the profession, and now they make up more than 50% of the profession. And there have been some notable achievements. I was conscious every couple of months I meet with the heads of bench in New Zealand, and that's the Chief Justice and the heads of the Court of Appeal and the High Court and other courts. And on this occasion I was there were 9 people in the room, and I realised I was the only man. Our Chief Justice is a woman, and her predecessor was a woman. So we have achieved a lot in certain areas, but across the profession at the higher levels we do not have women in those roles of power and influence. And so a lot of work is still needing to be done there. As I say, this is a very important program, and the Charter is So by signing up to this, so law firms sign up to this charter, and they agree to follow a set of ongoing commitments and to report to the Law Society every 2 years on what they are doing to meet those commitments. By signing up to the charter, signatories commit to leading from the top, making a plan and taking action, and measuring progress. The specific commitments include tackling unconscious bias, encouraging flexible working, closing the gender pay gap, and promoting equitable instructions to counsel and arbitrators and mediators. The Charter is open to the whole legal profession. Law firms, in-house legal teams, sole practitioners and barristers' chambers can all sign up to signal their commitment to gender equality and inclusion. This is an important program and it continues to be a work in progress. I don't want to suggest that we've already achieved equality at all levels. We must continue our work in this area. And something I'm conscious of too is that women in leadership and in the judicial leadership are also the subject of much more social media criticism than men in equivalent roles. Moving then on to Indigenous rights. So New Zealand's Indigenous people are the Maori. Before colonisation, they had a strong culture and a clearly defined legal system. Colonisation did what it did everywhere. It eroded well-being, rights, and destroyed a large part of the Indigenous culture and way of life. We are now seeing a resurgence of Maori culture, and we welcome that. And for an example, see how I started this speech. But it's important that we not fall into the trap of tokenism as well. The Law Society has put a lot of time and effort into the development of a Maori strategy that articulates our commitment to honouring the bicultural foundations of our country. This includes meeting our obligations as a modern regulator and representative body by reflecting Maori cultural values, equity and inclusion, and recognising the unique and enduring constitutional significance of Te Tiriti o Waitangi, the treaty. The treaty that is the founding document that was intended as a partnership between the Maori and the British Crown. Our strategy is a very practical document and speaks of what we want to be doing both internally and externally. So our logic is, as a profession, we have an obligation to uphold the rule of law. This means upholding our Constitution. Our Constitution is found in various documents, including the treaty. But when the treaty was signed, the Crown guaranteed property, it guaranteed customary law and their rights. That treaty was breached by the courts. It was by the Crown. It was breached. It was breached flagrantly. It was breached consistently. It is our responsibility to do everything possible to redress those breaches. And as you'll see from those figures, 20% of our population is Maori, and our profession and our judiciary must reflect those numbers. Our relationships and connections are important to us, and we are actively looking for opportunities to work alongside our Maori partners to address challenges and deliver services to the profession and our wider society. One example that is particularly relevant is what we do in the law reform space. It's important that the stronger and bigger entity, namely the Law Society, makes room for the Indigenous voice. That we don't just speak for them, but champion them and resource them to speak for themselves. In the law reform area, we have a very close relationship with our Maori Law Society. We fund a staff member to enable them to make submissions on law reform. We share information with them and empower them to make the best possible submissions. We also take care not to undermine their work and to make sure we are not speaking at cross purposes. As part of our strategy, the Law Society has also issued guidance for all lawyers regarding its expectations as a regulator. The guidance focuses on the relevance of Maori customary law and Maori-related legal developments in meeting their competence and client service obligations under the professional standards rules. There was just one final matter I thought might be of interest, and as president of the Law Society, I sit on a steering group for a program of work called Te Ao Marama. Literally, this means the world of light, and signals a more enlightened approach to justice in the district court. This was conceived of by our own Chief District Court Judge, Hemi Tamonu. He is a prominent Maori leader and a man deeply concerned about the failings of our justice system, particularly in its treatment of Maori. So Te Ao Marama is a judicially led district court program that partners with Indigenous tribes and communities to work with the court and justice sector agencies to ensure all court participants, including victims and family, can understand and better take part in the cases that relate to them. It is focused on family court care and protection, care of children and family violence cases, the youth court and the adult criminal jurisdiction. It's based on decades of evidence, reports and judicial advice that suggest changes and improvements in these areas to have the greatest impact. It is especially focused on supporting children and families who are at greatest risk when engaging with the family and criminal justice systems. Te Ao Marama has significant potential to reduce the number of children in care, the number of children who offend in the medium term, and the number of young people who enter the adult criminal jurisdiction in the longer term, all contributing to a long-term enduring reduction in offending and reoffending and the costs of crime. Te Ao Marama is inclusive of everyone, regardless of their ethnicity, culture, abilities, who they are and where they are from. It responds to repeated calls for transformative change over the past 4 decades and long-standing concerns expressed by victims, defendants, parties to proceedings and wider family members that they have found district court processes confusing, alienating, disempowering and re-traumatising. Te Ao Marama helps judicial officers and court staff to support victims in better ways. For example, there are more opportunities for victims and their families to speak during the court process. Te Ao Marama partners with local Maori tribes and communities to design and deliver family wraparound service solutions to meet each community's diverse needs. By extraordinary coincidence, this program was brought into existence at the same time as my youngest granddaughter was born, and her name is also Te Ao Marama. She has breakfast with me every day, and her presence to me is a constant reminder that we need to move towards a more enlightened world. So I want to finish by saying that diversity, inclusiveness and intersectionality are critical principles that we need to encourage, support and embrace. Now, that's all I have time for today, so I welcome the opportunity to speak with you all, and I welcome any questions later. Thank you.
Thank you so much, Fraser. In fact, it was interesting. I started taking down notes on what are the new things that you are sharing, because there were many laws that you mentioned which we do not have. While in India we are struggling with the period leaves, whether it should be there or not, mandated under law, you are talking about bereavement leaves. You're also talking about, in fact, in every family mediation, there are clauses nowadays dealing with the harmful digital content should not be released by either party. It's being written, but there is no law to that effect as such. You are referring to an amendment that has already happened. So in fact, as towards the end you did mention that let's lead towards an enlightened world, I think he has been a true torchbearer for that. Thank you so much. Now may I request Roger Chin, past President Sabha Law Society, to kindly address us.
I've got slides. Thank you so much for having me. It's obviously a privilege to be very much part of this conversation. And if we take this seriously, this conversation can reshape how we think about law, leadership, and fairness. Let me start with something real. In parts of Sabah, Mothers walk for hours to register a child's birth. They're turned away for small things, the spelling of a village, an incomplete form, not speaking Malay well enough. That child grows up without papers. That child is stateless. And with that, the doors to school, healthcare, and work quietly is shut and disappears. No law ever said, let's punish rural indigenous mothers. But the way we write and apply laws makes that the outcome anyway. That's intersectionality in action. It's not a buzzword, but as lived reality. It's what happens when gender, poverty, geography, and language stack up. And it's what the law often fails to see unless someone in the room has lived it. The term intersectionality came from Kimberlé Crenshaw, but the idea is much older. It's simply asking, why does the same law land differently depending on who you are? A poor single mother doesn't face the same barriers as a middle-class father. A stateless child doesn't have the same shot at rights as one born in the capital. Yet the law often acts as if they do and calls that neutrality. Neutrality sounds fair, but in law, it can be dangerous when it ignores the facts on the ground. And that's why who's in the room matters. Law is political, not just party political, but power political. And power shows up in who gets a seat at the table. In Malaysia, our Anti-Sexual Harassment Act took nearly 20 years to pass. It wasn't just lawyers who moved it. It was women's groups, survivors, activists, and a few persistent female MPs. People who knew exactly how harassment works and how the system often protects the harasser more than the victim. They didn't just write law, they rewrote what justice was supposed to mean. Let me give you a different example. In Sabah, our maintenance ordinance still caps support for an illegitimate child at RM50 per month, which is equivalent to USD 10 USD dollars a month. Yes, that's 50 ringgit, equivalent to 10 USD per month. Not per day, per month. That figure hasn't changed since the 1950s. It's not enough for a week of baby formula. It wouldn't cover your daily coffee for a week. Why is there even a legal difference between illegitimate and legitimate children? Why should a child's worth depend on the marital status of the parents? If single mothers had been in the drafting room, that figure would have been fixed decades ago. We see the same pattern in our native courts. These courts handle customary disputes, land, marriage, community justice. They exist alongside civil and Sharia courts, but they're underfunded, undervalued, and dominated by men, not because women lack knowledge, but because the system never imagined them as decision makers. If we're serious about inclusion, we can't just keep these courts alive on paper. We have to ask, who speaks in them? Who decides? Who benefits? History also plays a very important part too. In Sabah and Sarawak, intersectionality includes colonial inheritance. Take the Petroleum Development Act 1974, which was passed during emergency rule. And emergency rules are a colonial inheritance enshrined in our constitution. Centralized control of our oil and gas without the consent of our state assemblies, which effects are still felt today. Its revenue shortfalls, development gaps, and trust deficit between state and federal. These laws weren't written to reflect local realities. They were written to manage them, often from far away. If we want inclusive lawmaking, we have to rewrite these laws that were never inclusive to begin with. And here's a question I ask about the next generation of lawyers. What are we teaching them? It's not enough to know how to cite a statute or draft a contract. If you can't understand the lives of the people you serve, the law becomes a distant, abstract, and sometimes harmful. Some of the very best young lawyers I know come from communities where they've seen how the law falls. That gives them something you can't teach in a classroom: context and conscience. Law without either becomes a very tidy kind of cruelty. Intersectionality isn't a trend inclusion. It isn't a box to be ticked. It's about designing law for the world as it really is, not as we pretend it to be. It means acknowledging unequal starting points. It means unlearning neutrality when neutrality leads to injustice. It also means asking who the law is built to serve and being honest when the answer isn't everyone. The law doesn't need to be perfect, but it must be alive. Alive to context, alive to difference, alive to the people it claims to protect. The law sees what we choose to see. Let's choose to see everyone. Thank you.
Thank you so much. In fact, while listening to you, one thought that comes to my mind is you are not only emphasizing on fairness and level playing field, you are actually going back to the beginning of our session when we said now the emphatic declaration of the theme itself says the future is inclusive. There is no looking back. So we are talking about no more about becoming, and we are more talking about being, and being now. In fact, another thought that comes to mind is we heard different stories from different parts of the world. There were few things that were common. There were few things that were not so common. Few strategies that were common, few legal strategies that were not so common. But what really can bring us together and is now currently bringing us together is we as legal professionals stand in a very special position in the history of any nation to come together and use law as a tool of change as much as we can. And this time, instead of waiting for the organic evolution to happen, we can actually do it by design. And we can be more aware. As our last speaker, Mr. Roger Chin, said, we can be more alive to the situation. So with that, we can conclude the panel discussion. So far as if there are any questions, we can take them. And I would request all my colleagues here to respond to the questions, if there are any. Anybody having any perspectives, observations, remarks, questions?
Your experiences with reference to inclusion of persons with disability in your jurisdiction. Can I repeat? Now the mic has come. Large number of persons with disabilities are becoming lawyer in different jurisdiction. This question is addressed to the three panel members. Can you share development in your local jurisdiction about inclusion of persons with disability in the legal profession? Thank you.
Eh, 割合までちょっと申し上げることはできませんけれども、視覚障害者、聴覚障害者、あるいは車椅子等の身体障害者の方々が、あるいは精神障害者の方でも 弁護士になっていらっしゃいます。割合的には極めて少ないとは思いますけれども、その方々が弁護士会のさまざまな活動に参加していただきまして、日弁連では高齢者障害者の委員会というところでご活躍をいただき、市民の同じような障害者の方々の救済支援を行っています。
I don't have the percentage of the disabled persons who have the legal profession right now, out of the total size of the legal profession. However, we have quite a number of the visible, the despaired and auditory despaired, and also the people with wheelchair has become an attorney, and they are the members of the JFBA, and actually they are actively carrying out various activities in the committees, which is for the elderly and the disabled. And they are supporting various initiatives to help the people in the society who have disabilities.
Thanks. After you. I think in Sabah, which is a reflection of what is in the larger Malaysian context, is there are two issues here I think we must understand. The first issue is whether or not they can even make it into the law, meaning at university level. How well are differently abled people able to join a law program and qualify as a lawyer? That's the first issue. So I think we need to look at the universities and ask whether or not that has actually been enabled to allow that to happen to begin with. The second issue is, of course, is what are the courts or the bar, the law societies doing about those people who are differently abled? Are we assisting them in any way? And I think the reality is no, we're not. Okay? So you're talking about equipment that, for example, a person with sight disability, that person will obviously be paying for his or her own equipment. And similarly for someone who is hearing deficient, these people are obviously also paying for their own things. So I don't believe the bar is, or the courts are assisting them. I know in places like Taiwan, I was very impressed in Taiwan because they do provide reading glasses for people who go to court, not the lawyers specifically, but I'm talking about the parties. Reading glasses, and if I'm not wrong, they also provide them with some hearing assistance, if I'm not wrong. But that is the courts doing something about a situation which is in Taiwan. In Malaysia, the courts do not provide you with anything, okay? And I do not believe, there are a handful of blind lawyers in Malaysia, that I know for a fact. There is one in Sabah as well. But beyond maybe just helping the person get to court or pulling up a seat for that person when the person comes, there is nothing additional that is done. Of course, buildings have ramps which are built in to allow person with wheelchairs to access it, but that is a byproduct of the building bylaws. It's nothing specially done for them. But definitely when you talk about providing them with the necessary equipment to help them, whether it's an equipment to read to a person who can't see very well, no, that's not being included. So the two issues that I think we need to look at is whether or not the universities are doing anything to make sure that the differently abled people are actually entering university and qualifying as lawyers. And secondly, whether the courts and the bar are doing everything they can to make sure that these differently abled people are able to practice law in a meaningful way.
To Just picking up on probably similar trends, but in terms of our legislation, you can't discriminate, and you must provide sort of the physical support. And we would see this is another aspect of diversity in terms of our profession, that we need to have people that can represent everyone in our society. And those who are disabled will have a better understanding and ability to represent those clients. So it's actually quite important that we have members who can do that. And it's, as I say, it's our responsibility. But it's one thing to have the law that says you can't discriminate. It's also about attitudes. So this is where, as a law society, we need to be getting the message across. Law firms need to be employing. Roger talked about the universities. We need to be making sure they're coming through the universities, they're being looked after, and that they're coming into the profession, and that the profession is welcoming and receptive and encouraging, so that we can then, in turn, look after those people in society as clients to the best of our ability.
Just to share briefly the Indian scenario. So last year, 2024, the Supreme Court in fact came up with its report. The self-introspection exercise happened, and the entire Supreme Court infrastructure, both physical as well as digital, was analyzed, and the committee came up with a report. It's a very comprehensive report dealing with how to make the Supreme Court of India more accessible and disable friendly. So I think these kind of exercises of self-introspection definitely would help institutions, because so far as the bar associations are concerned, yes, the equipment and other hand-holding that is required, as of now, it doesn't exist. There are no bar associations specially addressing their concerns. So there definitely remains a gap over there. Any other questions?
I just wanted to make a comment about the need to keep pushing forward with these initiatives. There was a very interesting discussion at the IBA Bar Leaders mid-year conference about whether diversity and inclusion policies in law firms and in courts were appropriate. That was in the face of Trump having directed that all of the diversity and inclusion policies, or the DEI policies, came out of government, and a response from major US law firms to take down from their websites and to discontinue their diversity and inclusion initiatives. And the response from the bar leaders was all bar one agreed that there was a continuing need to keep these issues at the front of mind, and not to accept that these ideas are just woke or not appropriate, but they're in fact critical.
May I add something to Anil? Recently, Supreme Court passed a judgment and directed all the high courts and all the public service commission to provide 4% reservation in judicial services, including blind candidates.
As a Mongolian citizen, I think we must make a comment on this session, because, as you know, one of the positive externalities of a Mongol Empire was a name coined as Pax Mongolica, a peacetime during the Mongol Empire, which was a time where all diverse different religions and nations coexisted peacefully for a half century. So I think what the United Nations now is trying to achieve is to have that inclusivity and diversity coexisting at the same level. But we have seen a lot of international relations conflicts and tensions now getting where the interests of certain nations or certain groups is pushing their own rules, and now I think it is a very important time where the world needs to restore that spirit again. And that's why I think in terms of legal field, we have much to do to restore all those values of peaceful coexistence. So I think through that, we can do that through by soft law or through hard law, and I think through that way, I think a lot of aspects that is related to certain like religious or some other different beliefs can be resolved, and to attain peace at the worldwide level. Yes. Thank you.
Thank you so much. And one last observation. A question, preferably.
Thank you so much. And our respected last speaker, he brought very important issues. For example, inclusivity is not just about inclusion, but power, not party power, but the whole dynamics of power. It is in that sense we need to link this aspired for inclusion to what are the processes of transformations. Social transformation, political transformation, also transformation of the language of intersectionality itself. Because I'm a professor of sociology, and intersectionality sometimes reproduces a kind of a closed identity. And I have been developing an idea of transsectionality, because unless we transform intersectionality to varieties of transsectionality in terms of transcendental communication, and the inclusion, therefore, it is not just status quoist inclusion. How do we create a processes of transformative inclusion? And diversity, DIE, also in the difficult American context, both India and America, how do we link diversity to pluralization? And that pluralization is not just a socio-political project. That means how each one of us can be a better plural being. Thank you.
Thank you so much. I think with that we can conclude the session unless there are other. Thank you to the panel for bringing in so many different perspectives. As the last person in the audience who just mentioned that it's not about inclusion, it's something more. In fact, while taking down notes, I had 3 ideas. The last one, I was not sure whether to write it in this very manner or not. So it begins with inclusion. Then the next step would be transformation. And what I would like to see it as a revolution, completely changing the way that the issues that are being discussed now. We want a new discourse, in a new language, in a new era, where the inherent biases, discriminations, lack of fairness doesn't exist. That might be an utopian world, but taking from Fraser's word, it's all about us. So how can we at all leave anybody out? With that, we conclude this session. Thank you so much.
Which time?